Hello friends, and welcome to the SCDM website, and thank you for watching this video presentation on federal and state income taxation of individuals, Form 12.003. This presentation is brought to you by Sovereignty, Education, and Defense Ministry, SCDM, and you can visit our website at http://sedm.org. And here's our logo. If you would like to download a free copy of this presentation, you can visit our Liberty University at the link provided there as item 3.1, or you can visit our forms page and download form 12.003. And these materials come with a disclaimer. Information appearing in this presentation is educational in nature. We make no promises or guarantees about the effectiveness or accuracy of anything presented. Everything presented is based upon thousands of hours of research and scriptural legal research, and reviewed by and used by our several thousand members and growing. An exhaustive review of our website by the Federal Judiciary, the Department of Justice, and the Internal Revenue Service, which did not find anything factually wrong with anything currently posted on this website. And for the details, visit the link provided here. And it's also based on continuous feedback from our readers that have improved the quality of the information over time. If you find any inaccuracies in this presentation, our member agreement, Form 01.001, makes it a duty of all members to promptly bring the error to our immediate attention with supporting evidence so that we may continually improve our materials. Your evidence must be completely consistent with our presentation below, entitled Reasonable Belief About Income Tax Liability, Form 05.007, which you can download from our forms page. The application of this information to your specific legal circumstances is entirely your choice and responsibility, and the information presented is copyrighted and subject to the copyright restrictions found on our disclaimer page. You should not and cannot use any of this information without consenting unconditionally to and complying fully with the terms of our member agreement, Form 01.002, Section 2, and this disclaimer is the same disclaimer as the U.S. government uses. See Internal Revenue Manual, Section 4.10.7.2.8. They also say that you cannot rely upon any of the information published on the Internal Revenue Service website, any of their publications, or any of their forms for that matter. And this non-commercial video is protected by the Fair Use Doctrine of the Copyright Act, 17 U.S.C., Section 107. And please consult our Digital Millennium Copyright Act page if you have copyright issues at the link provided. We also want to start out with an admonition by saying that if you are using government services, then you should pay for everything you use. Don't pay your, quote, fair share, unquote. Pay what the law says you owe and nothing more. Fair share is too subjective, and when used as a criteria in court, politicizes and corrupts the courts. The following persons are irresponsible and thieves: those who do not pay for all the services they use, those who collect more from an unwilling taxpayer than is necessary to pay for the services they use, or those who collect anything from a person who does not want or does not need government services and who refuses to declare a domicile within the jurisdiction of the state. See why domicile and becoming a taxpayer require your consent, Form 05.002. Your public disservants selfishly only concern themselves with the first of the three items above. We ensure that they worry about all of the items above, because if they don't, they, and not you, are the thief. If you are going to use the information in this presentation to lawfully avoid taxes, you should also agree to stop using the government services that they pay for. This is the only way to be a responsible American and avoid burdening or hurting your neighbor. We believe that those who do not wish to contribute anything to the tax system should always have a lawful option to divorce the state and refuse to accept government services or the obligations that go with them. This is what it means to live in a free country, in fact. And government is a corporation, and like any other corporation, we should have a right to not do business with them. See 28 U.S.C. 3002-15A. To admit otherwise is to admit that the government can compel you to contract with them in violation of Article 1, Section 10 of the United States Constitution. Learning objectives. To teach the basics of reading and understanding the Constitution, statutes, and regulations. To review the conclusions of the following relating to citizenship and Sovereignty course. To explain precisely who are statutory, quote, taxpayers, unquote, under Subtitle A of the Internal Revenue Code. Everyone else is by implication a non-taxpayer, not subject to the Internal Revenue Service jurisdiction. And to explain what types of income really are taxable to, quote, taxpayers, unquote. To describe the relationship between state and federal income tax schemes. To review overwhelming evidence documenting misenforcement of the tax laws by the IRS and the state tax authorities. To describe educational materials and services that SEDM offers to non-taxpayers domiciled outside the federal zone who want to defend their rights and their property from unlawful and injurious actions by the IRS, and to give you a starting point for further research and education into the subject of personal income taxes. And here is an outline of this video training in the sequence it will be presented. Who are individuals? The Constitution, statutes, regulations, Federal Enforcement Authority, words of art in the law, definitions, precedents and hierarchy of law, Citizenship and Sovereignty course review, citizenship status versus tax status. What is a tax? Who are, quote, taxpayers, unquote. The nature of the IRC Subtitle A. Quote, taxable income, unquote. Item 14. The government tax fraud. State versus federal income taxes. State income taxes. Example, California. Flawed Tax Arguments. Getting Connected, Resources. Sovereignty, Education, and Defense Ministry. SEDM Curricula. And questions. And we also want to emphasize that with an important preliminary note, the following. We do not challenge the constitutionality of any part of the Internal Revenue Code. It is completely constitutional and lawful. And what is unconstitutional is the way the IRC is represented to the American public, administered and enforced by the IRS. The most of the illegal administration and enforcement of the IRC results from omission, not commission. Our enemy is not the government, the IRS, or even taxes, but instead is legal ignorance on the part of Americans that allows public servants to abuse their authority and violate the law. The abuse of presumption to injure the rights of sovereign Americans in violation of due process of law and God's law, found in Numbers 15:30, New King James Version. Much of this presumption is compelled by government by willfully dumbing down the average Americans about legal subjects in the public, that is the government, schools. This makes the legal profession into essentially a priesthood and a pagan religion that the average American blindly worships and obeys without ever questioning authority. It is a supreme injustice to proceed against a person without every conclusion being based only on fact and not presumption, opinion, or belief. See the following for a detailed article on this scam and sin. Presumption, chief weapon for unlawfully enlarging federal jurisdiction, Form 05.017, available on our website. And number 3, public servants deceiving the public by portraying private law as public law. See the following for an article on this subject. Requirement for consent, Form 05.003. Public servants refusing to acknowledge the requirement for consent in all human interactions. See the following for extensive article on this subject. Requirement for consent, Form 05.003 on our website. Number 5, willful omissions from the IRS website and publications that keep the public from hearing the whole truth. The problem is not what these sources say, but what they don't say. The Great IRS Hoax, Form 11.302, contains over 2,000 pages of facts that neither the IRS nor anyone in government is willing to reveal to you because it would destroy the gravy train of plunder that pays their bloated salaries and fat retirement in violation of 18 U.S.C. 208. Number 6, the use of words of art to deceive people in both government publications and the law itself. See the link on our on the Family Guardian sister site. Number 7, the lack of equal protection of the law in courts of justice relating to the statements and actions of public servants, whereby the IRS doesn't have to assume responsibility for its statements and actions, and yet persons who fill out tax forms can be thrown in jail and prosecuted for fraud if they emulate the IRS by being just as careless. This also includes selective enforcement, where the DOJ positively refuses to prosecute submitters of false information returns, but spends a disproportionate share of its resources prosecuting false income tax returns. They do this because they are more interested in stealing your money than in justice. See, federal courts and the IRS's own IRM say they're not responsible for its actions or its words or following its own procedures on the Family Guardian Sister site. Requirement for equal protection and equal treatment, Form 05.003 or 033 on our website. And government establishment of religion, Form 05.038, how government establishes itself as a pagan deity and a religion by using franchises to systematically destroy the separation of powers and the requirement for equal protection. And number 8, the abuses of franchises that undermine the protection of private rights by government and the courts. And this includes enforcing federal franchises within states of the Union, which are outside the civil jurisdiction or police powers of the federal government and result in a destruction of the separation of powers. 8.2, enforcing franchises such as a trade or business without requiring explicit written consent in some form, such as the issuance and voluntary signing of an application for a license. See Government Instituted Slavery Using Franchises, Form 05.030 on our website. Attorney licensing, which destroys the integrity of the legal profession in its role as a check and balance when the government, or especially the judiciary, becomes corrupt as it is now. 8.4, the abuse of federal income tax system, which is a franchise and an excise to bribe states of the Union to give up their sovereignty, act like federal, quote, states, unquote, and territories, and accept what amounts to federal bribes to disrespect the rights of those under their care and protection. Item 9. Efforts to destroy the separation of powers that is the main protection for our liberties. This results in abuses of the court system for political rather than legal purposes, that is the politicization of the courts. All of the federal courts we have now are Article 4 territorial courts that are part of the executive rather than the judicial branch of the government. As such, there is no separation of powers and nothing but tyranny can result. See the following for proof. Government conspiracy to destroy the separation of powers, Form 05.023, which shows how lying, thieving public servants have systematically destroyed the separation of powers since the founding of this country. And What Happened to Justice, Form 06.012, which is a book that proves that we have no judicial branch within the federal government and that all existing federal courts are acting in an Article 4 territorial capacity as part of the executive rather than the judicial branch of the government. And 9.3, How Scoundrels Corrupted Our Republican Form of Government, which is a brief overview of how the separation of powers has been systematically destroyed over the years. Item 10, the abuse of the government's power to tax in order to transfer wealth between private individuals, which makes the government into a thief and a Robin Hood. This includes enforcing the tax laws against other than public officers in the government. See why your government is either a thief or you are a public officer for income tax purposes. Offering government benefits of any kind to anyone who does not already work for the government. See Government Benefits Scam, Form 05.040. Item 11, corruption of our monetary system that allows the government to counterfeit while denying to all others the right, thus creating an unconstitutional title of nobility for itself and making itself into a pagan deity and denying the equal protection to all that is the foundation of the Constitution. 11.2, to steal from American people by diluting the value already in circulation. And 11.3, exercise undue control over banks and financial institutions that causes them to effectively become federal employment recruiters for the federal government by compelling the use of government identifying numbers for those pursuing accounts or loans. See the following. The money scam, Form 05.041. So let's get started with the presentation. Who are, quote, individuals, unquote? And the reason we put it in quotes is because the individual we're talking about is a statutory individual rather than a common law human. This course is about federal and state income taxation of, quote, individuals, unquote, as legally defined and not commonly understood. The Internal Revenue Code deliberately does not define the term, quote, individual, unquote. Individual is defined at 26 CFR 1.1441-1C3 within the regulations as a, quote, alien individual or, quote, non-resident alien individual, unquote. Note in this definition that citizens are not included in the legal definition of individual, that non-resident alien individuals are not a subset of, quote, alien individuals under this regulation, that all taxpayers, unquote, under the Internal Revenue Code Subtitle A are alien individuals, and that those who are non-resident aliens but not individuals have no liability to file a return or to pay a tax, and that this is the same individual mentioned in the upper left corner of the IRS Form 1040 in the phrase, quote, U.S. individual income tax return, close quote. 5 U.S.C. 552A, paragraph A2 clarifies that this, quote, individual, unquote, is an officer or employee of the national government. That section of the code is in Title V and regulates public conduct, not private conduct, meaning activities of public officers within the government. The ability to regulate private conduct, according to the U.S. Supreme Court, is, quote, repugnant to the Constitution, unquote. And this individual is domiciled in the, quote, United States, unquote, which includes federal territories called, quote, states, unquote, in federal law, and possessions, and nowhere is defined to include any state of the Union. What the citizens and residents mentioned in this statute have in common is a domicile on federal territory, and they collectively are called, quote, U.S. persons, unquote, in 26 U.S.C. 7701 A30. 5 U.S.C. 552A, paragraph A13, and 5 U.S.C. 2105 further clarify that this, quote, individual, unquote, statutory individual, is an officer or employee of the national government. And here's what it says, 5 U.S.C. 2105A. For the purposes of this title, employee, except as otherwise provided by this section or when specifically modified, means an officer and an individual who is, and then they list all the types of public officers. Notice within this definition that the term, quote, employee, unquote, is never expressly defined to include an ordinary worker within the national government who has, for instance, a supervisor. So everybody within Title V who is a statutory employee is both a public officer and an individual, and in fact, being a public officer is the only way that they could be an individual, because otherwise they would be private, and the ability to regulate private conduct is repugnant to the Constitution. That's what the Bill of Rights is for, to prevent those rights from being regulated, taxed, or affected in any way by any government. So if anybody calls you an employee, if you fill out a form that identifies you as an employee, such as a W-4 in the upper left-hand corner, which is entitled Employee Withholding Allowance Certificate. So in effect, if you fill out that W-4, you are declaring yourself to be this type of employee. And it has to be this type of employee and public officer because, as I said, the ability to regulate private rights and private conduct is repugnant to the Constitution. 26 U.S.C. 6331 further defines who this, quote, individual is by describing who the Internal Revenue Code may lawfully be enforced against. And here it is, paragraph A, the authority of the Secretary. If any person liable to pay any tax neglects or refuses to pay the same within 10 days after notice and demand, it shall be lawful for the Secretary to collect such tax and such further sum as shall be sufficient to cover the expenses of the levy by levy upon all property and rights to property except such property as is exempt under 6334 belonging to such person or on which there is a lien provided in this chapter for the payment of such tax. Levy may be made upon the accrued salary or wages of any officer, employee, or elected official of the United States, the District of Columbia, or any agency or instrumentality of the United States or the District of Columbia by serving a notice of levy on the employer, as defined in Section 3401D, of such officer, employee, or elected official. If the Secretary makes a finding that the collection of such tax is in jeopardy, notice and demand for immediate payment of such tax may be made by the Secretary, and upon failure or refusal to pay such tax, collection thereof by levy shall be lawful without regard to the 10-day period in this section. Now, first of all, we want to point out that the levy may be made only upon those employed by the government. It may not be made upon private parties. Why? Because once again, the ability to regulate or tax private property and private rights is repugnant to the Constitution. That's what the Constitution protects. That's the only thing that it protects, is private property and private rights. Now, on the other hand, this levy would be directed against public property and public rights, meaning property already in the possession, control, or ownership of the national government, and only the national government. And that is why this section is so damning as far as sending out levy notices, because when the IRS does send out levies, Form 668s, to various entities, the back of that levy notice contains a warning, and it actually contains a part of this section, Section 6331A, but it very conveniently omits paragraph A, because the goal of sending out the levy is to levy private property instead of public property, and to, in effect, violate the Internal Revenue Code and violate the jurisdiction of the government by levying against those who are not public officers in the government. And we emphasize that all individuals are public officers. So, sure, they can levy the pay of their own officers because they can make that a condition of their employment agreement. And we would argue, in fact, that the entire Internal Revenue Code, subtitles A and C, are nothing but a big employment agreement for people who work for the government and nobody else. And by employment, we also include public officers, because and corporations, because corporations are also franchises of the national government. So when we say employment, we really mean public officers or employees who work only for the government. The other thing is that it says officer, employee, or elected official. All three of these, we just found out, are synonymous. Section 2105A shows that. And it says the District of Columbia or any agency or instrumentality of the United States or the District of Columbia. So basically, they can only serve a levy upon an instrumentality of the government. And an instrumentality would not include a private business. It wouldn't include a bank. It wouldn't include a private business. And the fact that these entities that they're sending levy notices to are not private businesses means that these levy notices are being illegally sent to the wrong parties. And if they do believe that these instrumentalities or these agencies are in fact part of the government, they have the burden of proving that they are. They can't just mail these notices to otherwise private parties who think they're private parties and impose duties upon these private parties because to take money from people or people who work for them, because that would be theft, number one. Number two, it would be a violation of due process of law, because the Constitution Fifth Amendment requires that the government cannot take property without due process of law, which means that they have a burden to prove that the party that they're taking from works for the government. And if they aren't able to prove that, then everything beyond that is a tort. Now, those private institutions that do receive these levy notices, the 668 forms, typically do not research Section 6331 mentioned on the back of that levy notice, and so they don't read paragraph A that's been deliberately omitted from the form. But if they do call the IRS and point out paragraph A to the IRS, and that therefore they can't lawfully levy the pay of this person, the IRS will essentially lie to the people they're talking to, and they'll do it with impunity. They'll say, oh yeah, we can do that. Well, no, you can't. The law doesn't allow it. The whole purpose of law, we want to emphasize, is to define and limit government power, according to the U.S. Supreme Court. and it cannot function in that capacity as a delegation order to define and limit government power if the statutes do not include everything somewhere that is included. And there's no place anywhere in the Internal Revenue Code where the term person or individual or even income is associated with anything other than a public office in the government or a government payment. And we also want to emphasize that the Internal Revenue Service's website in their Internal Revenue Manual specifically says that you cannot trust anything they say, anything in their publications, or anything in any one of their forms. And that being true, the Form 668 levy notice is included in that, and therefore you cannot trust this notice. And if you can't trust it and you can't rely upon it as a basis for a requirement to do anything, then why would you want to honor it? And if you do honor it, aren't you really jeopardizing your business and your institution by honoring it? Because you're assuming all the risks of enforcing this form because you can't rely on anything that the IRS says or anything they print or publish or any of their forms or any of their publications. You can't really even rely upon the advice of an attorney unless you're involved in a criminal dispute. And so, in effect, you take all the liability for the misenforcement and misapplication of the Internal Revenue Code against parties who are not liable. And our question to you is, do you really want to do that if you own a business or if you're a small business owner? We think it's insanity, in fact. Why are public officers the only taxpayers? The tax is an excise tax upon a trade or business, quote unquote, which is defined as, quote, the functions of a public office in 26 U.S.C. 7701A26. And we prove this in our form, the Trade or Business Scam, Form 05.001. And 4 U.S.C. Section 72 mandates that, quote, all offices attached to the seat of government shall be exercised in the District of Columbia and not elsewhere except as otherwise expressly provided by law. And if you search the entire Internal Revenue Code, you will find almost no instances where, or any other code for that matter, you'll find very few instances where the public offices that are the subject of the tax are expressly authorized to be exercised outside the District of Columbia. And therefore, by implication, all those offices and all taxpayers must be located in the District of Columbia and must be offices of the national government, within the national government. The taxpayer, in fact, is the office and not the person filling the office, which is also called the officer. So the taxpayer is the office, and that office is a legal person, and that legal person is representing a corporation, a federal corporation, the United States, and that United States has a domicile in the District of Columbia, and so the effective domicile of the person and the taxpayer, like that of its corporate parent, is only the District of Columbia and not elsewhere. Moving on, a public office is a franchise, and all franchises make you part of the government and place your domicile on federal territory while on official duty, regardless of where you physically are, pursuant to Federal Rule of Civil Procedure 17b. See Sections 7 and 8.4.5 of the Government Instituted Slavery Using Franchises, Form 05.030 for the proof. And the U.S. Supreme Court has held that the ability to regulate private conduct is repugnant to the Constitution. City of Bern versus Flores, and Edmondson versus Leesville Concrete Company. And constitutional rights do not apply to public officers, but they do protect private conduct. Rutan versus Republican Party of Illinois. So, in other words, all their laws can and do, the civil laws at least, can and do regulate only public officers and employees on official business. And the purpose for regulating them is to ensure that they don't injure your private rights, your constitutional rights. And by rights, we don't mean public rights, we mean private rights. There are two types of rights. The opposite of private is public. You can only tax persons who don't have rights, or else you would be stealing from them. The only place in the country where constitutional rights do not exist and everything is a privilege is federal territory. and the only type of, quote, persons, unquote, who don't have rights are anything other than biological men and women, such as corporations. And the federal government is a corporation, as defined in 28 U.S.C. 3002-15A. So, in other words, the only people who really have private rights or constitutional rights are human beings. And those rights are unalienable according to the Declaration of Independence, which is organic law as found in the statutes at large in the very first enactment of Congress. And so those rights are unalienable, which means you aren't allowed to give them away. And so the only people who can really have rights are human beings. Everything else, including artificial entities, businesses, and corporations, have no inherent rights. All they have are privileges, and those privileges are imputed to them by the civil laws, which are all franchises enacted by the national government, and those franchises regulate in effect only public property and public rights of public officers and public offices on official business. Otherwise, the ability to regulate private rights and private conduct is repugnant to the Constitution, as we pointed out. So, nearly all statutes passed by the government regulate only public conduct and not private conduct, and we prove this in why statutory civil law is law for government and not private persons. Form 05.037, available on our website on the Forms page. And the Internal Revenue Code is statutory law as described above, and federal government has no enforcement authority inside of a state of the Union. And we prove this in Form 05.032, federal enforcement authority in states of the Union, on our Forms page. Moving on, the Constitution is written by, quote, we the people, unquote, as individuals. A sacred contract, it is a sacred contract between the states of the Union and their servant government, and the purpose is to protect the people from usurpations by their government by limiting and defining government power. It delegates certain powers from the people to their government and specifically reserves those powers to the people that are not delegated in writing. And it's written in very simple language so that it can be read and understood by the general public. And all federal law is written based on authority derived directly from the Constitution. However, we want to qualify this statement by saying that federal law does not include law that's applicable only to territories or territory of the national government. Federal implies the national government in relation to the constitutional states. It does not imply the national government in relation to territories or possessions of the United States. There are no constraints on how Congress treats those entities, the territories and possessions of the United States. They can do whatever they want within those territories and possessions of the United States. And in fact, they do. And we would argue further that the income tax laws can and do only apply to those places and not to the constitutional states. And that is very evident by reading the definitions found in the Internal Revenue Code, Section 7701, and all of the regulations as well. And if you push those definitions and the rules of statutory construction that constrain their interpretation in front of an IRS agent or a court, they have no defense to explain why they're enforcing in a place that the law doesn't authorize. And consequently, they're engaged in treason and theft and slavery in the process. And they have no defense for it. And word games is just a naked way to steal from people. As we said before, the purpose of all law is to define and limit government power, not your private rights. And so all laws passed by Congress, for the most part, except possibly the criminal laws, can and do regulate only public officers and public offices and instrumentalities of the national government, whatever they may be. And the Constitution may be disobeyed and disregarded by public servants. It says may not be disobeyed or disregarded. Officers of the government must take an oath to support and defend it. See the Constitution of the United States, Article 6, Clause 3, and Article 2, Section 1, Clause 8. See also 28 U.S.C. 453 and 5 U.S.C. 3331, which is the oath. Disobedience of the Constitution amounts to perjury of the oath and treason, which is punishable under Article 3, Section 3, Clause 1, and 18 U.S.C. 2381. Moving on with the Constitution, rights are defined but not created in the Bill of Rights, which is the first 10 amendments to the Constitution of the United States. When citing sections of the Constitution, the convention is to cite the following in the order shown: article, section, and clause. For instance, Article 1, Section 8, Clause 1 is the clause that grants Congress the power to tax within the Constitution of the United States. And here's an example from the Constitution. Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States, but all duties, imposts, and excises shall be uniform throughout the United States. And you can read the annotated Constitution on the FindLaw website yourself for free. Statutes. The purpose is to implement the powers delegated to Congress by the Constitution. And there are two classes of statutes: the statutes at large, also called SAL, and the U.S. Code, also called USC. The statutes at large is published for each session of Congress. It's published in volumes. Only the last few years are available online. Further back, you need to the online version of the statutes at large, available from Potomac Publishing. An example cite from the statutes at large would be Revenue Act of 1939, 53 Stat 1, where 53 equals volume 53 and 1 means page 1. The U.S. Code, on the other hand, is divided by title or subject. There are 50 titles in the U.S. Code currently. Not all titles are enacted into positive law that is binding upon everyone, and titles which are not enacted into positive law are considered, quote, prima facie evidence of law, unquote. And by prima facie, we mean presumed. And we know that per the Constitution, due process of law does not permit any sort of a presumption. So any so-called, quote, law, unquote, or code, which is prima facie evidence of law, is a presumption and therefore cannot be enforced against those who are protected by the Constitution. The Internal Revenue Code, Title 26, is not positive law, but only prima facie evidence of law because it was not enacted into positive law, and therefore it can only apply to people who have consented. Otherwise, it's not evidence of anything, any obligation at all. And an example cite from the Internal Revenue Code, 26 U.S.C. 861, where 26 equals Title 26 of the U.S. Code, and 861 means Section 861. Regulations are often called rules in the legal profession, and their purpose is to implement or administer statutes. Statutes are the legal skeleton, and the regulations put meat on the skeleton. And they assign a specific agency to take responsibility for investigating and enforcing specific statutes, and they inform the public of how statutes are interpreted and applied to them when published in the Federal Register. So typically what happens is Congress enacts a law first in the statutes at large, and after it's published in the statutes at large, the Law Revision Council of the House of Representatives will write or implement that statute at large into the U.S. Code by dividing it up by title and section. And so they will expand the U.S. Code based on the enactment of Congress. And after they've written their statutes in the U.S. Code, then the agency responsible for that title of the code is tasked with writing regulations to implement the statutes in the U.S. Code. And those regulations in turn are then published in the Federal Register as they are created. And after they've been published, they form a part of what's called the Code of Federal Regulations, or CFRs. There are three types of regulations: legislative, which have the force and effect of law. They're written by the Secretary of the Treasury, and an example would be regulations under 26 U.S.C. 7872 H1. Another type of the three types is interpretive regulations, which have the force and effect of law. They're written by the Secretary of the Treasury in satisfaction of 26 U.S.C. 7805A, and they're found in 26 CFR Parts 1, 31, and 301. And there are also procedural regulations which do not have the force and effect of law. They're written by the IRS, and they're found in 26 CFR Part 601. and they implement Subtitle F, the Internal Revenue Code, entitled Procedures and Administration, within sections 6001 and 7873, and they contain procedures to be followed by the IRS in executing a statute, and not even the IRS is bound to follow procedural regulations except in cases where not doing so would adversely affect the rights of the public. See Morton versus Ruiz, 415 U.S. 199, 1974. So how do we tell what type of a regulation it is? When regulations are issued, they include a paragraph in the transmittal stating the authority under which they are issued. Regulations are found in the Code of Federal Regulations, which in turn is organized by title and published in accordance with the Title I of the Code of Federal Regulations. And the publication in the Federal Register, as we said earlier, occurs before the items are added to the Code of Federal Regulations. And the purpose is to give the public reasonable notice of laws which will be enforced against them. 44 U.S.C. 1508. You cannot enforce a law until you give those who are the target of enforcement notice. And we prove this in the requirement for reasonable notice, Form 05.022. And the bottom of the regulation or notes for the regulation indicates if and where published in the Federal Register. If there are no such notes, it was never published in the Federal Register. And if it was never published in the Federal Register, then it only pertains to the government and no one else. That's very important. And when published in the Federal Register, it becomes effective against the general public and is published in accordance with the Administrative Procedures Act, which is found in 5 U.S.C. 551 through 559. And regulations need not be published in the Federal Register if they will only affect federal employees, federal agencies, or federal instrumentalities. See 44 U.S.C. 1505A and 5 U.S.C. 553A. Important things to remember about regulations. Only legislative and interpretive regulations are binding on the general public. Procedural regulations are not. And for tax purposes, the Treasury writes all legislative and interpretive regulations. And regulations are not applicable to the public in general if not published in the Federal Register, even if they are legislative or interpretive regulations. And without an implementing regulation published in the Federal Register, a statute is unenforceable against the general public domiciled in states of the Union, and is enforceable only against federal entities, instrumentalities, employees, officers, contractors, and benefit recipients. See 44 U.S.C. 1505A and 5 U.S.C. 553A. In many cases, the implementing regulation for a specific law looks exactly the same as the portion of the statute that it implements. For such a case, the regulation adds nothing to the statute but is still necessary under the Administrative Procedures Act in order to enforce the statute against the public at large. And federal agencies may not use the regulations written by other agencies. See 1 CFR 21.21c. Now, the regulations and understanding how they work are very important because they're an excellent way to put boundaries on the federal enforcement authority. Or by that we mean the authority of the federal government to enforce within states of the Union. Otherwise, we would say the National Enforcement Authority. The effect of failure to publish regulations in the Federal Register is as follows. 26 CFR 601.702, Publication and Notice of Inspection. Paragraph A2 II, effect of failure to publish. Except to the extent that a person has actual and timely notice of the terms of any matter referred to in subparagraph 1 of this paragraph, which is required to be published in the Federal Register, such person is not required in any matter to resort to or be adversely affected by such matter if it is not so published or is not incorporated by reference therein pursuant to subdivision I of this subparagraph. Thus, for example, any such matter which imposes an obligation and which is not so published or incorporated by reference will not adversely change or affect a person's rights. So this is very important. If they don't publish it in the Federal Register, then it doesn't affect you, the public. And therefore it can only affect the government and people in the government and no one else. And there are many cases, especially the enforcement provisions of the Internal Revenue Code, where this is the case. And that would include liens, levies, and distraint or seizures and so on. So, and that also includes all of the provisions dealing with injunctions. They don't have any enforcement regulations that would apply those to anything but people in the government. So the injunctions are being misenforced in most cases, and that was true when they went after our ministry, and it's true in many other cases. The above is also repeated in 5 U.S.C. Section 552, paragraph A1. Public information, agency, rules, opinions, orders, records, and proceedings. Except to the extent that a person has an actual and timely notice of the terms thereof, a person may not in any manner be required to resort to, be adversely affected by, a matter required to be published in the Federal Register and not so published. For the purposes of this paragraph, matter reasonably available to the class of persons affected thereby is deemed published in the Federal Register when incorporated by reference therein with the approval of the Director of the Federal Register. Groups specifically exempted from the Federal Register publication requirements include only the following, all of which are in the executive branch of the government: a military or foreign affairs function in the United States, 5 U.S.C. 553, paragraph A1, a matter relating to agency management or personnel or to public property, loans, grants, benefits, or contracts, 5 U.S.C. 553, paragraph A2, and federal agencies or persons in their capacity as officers, agents, or employees thereof, 44 U.S.C. 1505 A1. So, we should notice here that this last item, item 3, would include taxpayers, all taxpayers, we might add, because you cannot be a taxpayer without being an officer or employee of the national government. And therefore, no regulations are required in order to enforce those provisions against those who are taxpayers. But we also want to emphasize that most people are not taxpayers, and that would include everybody in a state of the union who does not lawfully occupy a elected or appointed office in the national government. And we also want to emphasize that you cannot unilaterally elect yourself into a public office by filling out any government form. The office is not created by any provision in the Internal Revenue Code. It is created only by a lawful election or appointment under Title V of the U.S. Code, and very few people who are taxpayers, very few people in general, much less those who are taxpayers, would be covered by that provision. So, for the most part, most Americans are not taxpayers. They have been deceived into thinking that they are, with devious words of art, deception, and the abuse of the word includes, and the violation of the rules of statutory construction to fool them into thinking that they work for Uncle. And why are they doing that? Because they want to confuse the public and the private so they can steal the private. And we might add that governments are established for the protection of only private rights. And the very first step in that protection is to make sure they are not converted to public rights or public offices or public property without the express written and informed consent of the owner. And that never happens. So in effect, all they want to do is the opposite of the purpose for which they were created, which is to protect private rights. They want to steal private rights and not protect them. And they really only protect their own stuff, their own property, and they want to make everything their property. They're like a Borg. They're like a Pac-Man. They want to swallow everything up. They want to confuse the public and the private and assume everything is public. And, you know, if you step back and think about that, really, I mean, that's the essence of socialism, isn't it? Socialism presumes either government control or government ownership of everything. And so that's how they implement it. They create false presumptions that they own everything and that you work for them and that it's all unknown to you and that you have to do whatever they say. And if you don't do it, then they'll steal everything you own. And that is what we would call economic terrorism. And it violates Article 4, Section 4 of the Constitution. So the reason for the above 3 exemptions from the Federal Register publication requirement are that the executive branch is the servant of Congress, who is the master, and Congress commands the executive branch through statutes, and the servant cannot be greater than the master. And if enforcement against the executive branch employees required implementing regulations before it was permissible, then the executive branch could use its authority to write implementing regulations to undermine the enforcement of the law by refusing to write implementing regulations. So in other words, the servant cannot circumvent the master, and the master is Congress. They write the laws. The laws are implemented by the executive branch in the form of regulations, and so you don't have to have a regulation to enforce those statutes against people in the executive branch. you only need the regulations to enforce them against people in the general public instead. So, and this ensures accountability. If they didn't do it this way, then there's no way the legislative branch could hold the executive branch accountable under the statutes. Because at that point, the servant could simply say, well, I haven't written the regulations yet, and therefore I don't have to follow them. And then what could Congress do? Nothing. So that's why they do what they do here. To meet the burden of proof that they have jurisdiction to enforce a specific statute, the federal government must produce evidence of one of the following. This is very important. Proof of publication of enforcement regulations in the Federal Register for all statutes sought to be enforced, or proof that the target of the enforcement action is a member of one of the three groups specifically exempted from the Federal Register publication requirements as indicated above. So either they publish it in the Federal Register so it affects everybody in the public, or number two, they have to prove that you're in the government and therefore that they don't need regulations. One of those two. That's how it works. Now, typically, simpletons, those who are legal neophytes, don't understand these concepts. People like, Eddie Kahn, promoted the idea that they need federal implementing regulations, and he was wrong because his argument was incomplete. He only included item 1 here, and he didn't understand item 2. So he was overly simplistic in stating that they had to have regulations, because they don't. They don't have to have regulations if you work within the government as an officer, employee, or instrumentality of the government. They don't need them. And he didn't understand that. And he also didn't understand that all taxpayers are public officers, and therefore they fit within the boundaries of item 2 here, where no implementing regulations are required. Okay? He also didn't understand that most people are not taxpayers. He couldn't explain it. So his argument was incomplete, and as a consequence of his simplistic approach, he ended up in jail. And so this is very important stuff to know. He is now in jail for over 10 years, and he's sentenced to over 10 years in jail because of his misunderstanding of the of this specific matter. Okay, and that was in connection with a criminal prosecution of Wesley Snipes for tax fraud. And Wesley Snipes was acquitted of the fraud charges, and Eddie Kahn took the brunt of them as his tax preparer. The above requirement is an excellent method for challenging the jurisdiction of any federal enforcement action in federal court. We like to use it as often as possible. And there's no defense against it. Either they produce the regulation so that it applies to the general public, or they produce evidence that you work in the executive branch of the government as an officer of the government. One of the two. And the evidence that you work in the government would be an SF-71, 171 form, an official, an oath, and a desk, and a retirement plan, and all that other stuff. Okay, they can't produce any of that. So either way, and most enforcement provisions of the Internal Revenue Code do not satisfy item 1 here, and they can't prove item 2 either. So they're stuck, and that's a great place to keep them stuck, because at that point they have to dismiss the case against you, and they have to give you your money back. Most freedom researchers forget item 2 above and lose in court when they challenge federal enforcement jurisdiction. Be careful. And we pointed out one of those people, Eddie Kahn. And Eddie Kahn even published an entire book on federal enforcement regulations, and we bought it, and it was incomplete. And we even pointed it out to him, and he didn't want to listen. And look what happened to him because he didn't listen. So don't be dumb like that, okay? Trying to keep you out of trouble. Federal enforcement authority is exhaustively explained further in Federal Enforcement Authority within States of the Union, Form 05.032, available on our website. And for an example of how to stop an illegal IRS collection in the State of the Union, see IRS Due Process Meeting Handout, Form 03.008. And that form basically breaks out all the enforcement provisions in the statutes of the Internal Revenue Code and shows that there are no implementing regulations, and therefore they can only apply to people in the government, and at that point the IRS has to prove that you work for the government, and they can't prove it. So in effect they have to stop their enforcement activity. Words of art in the law. Most corruption and injustice within the legal field is done using sneaky definitions to deceive the people. These definitions are called words of art, and you should read the definitions before you read the rest of the law, and this will keep you from being deceived. The definitions in the Internal Revenue Code are at the end, not the beginning of the code, because the government, quite frankly, doesn't want you paying attention to them. And you should trust your own judgment when you read the law and don't rely on an expert. The Supreme Court says the laws are supposed to be understandable by the common man. And to the extent that they aren't, they are what is called void for vagueness and unenforceable. After the government obfuscates the law using tricky definitions, they will try to convince you that you can't trust your own judgment when reading the law. This forces you to rely on a corrupt judge or a lawyer to interpret the law. It puts your liberty in the hands of someone else instead of you, and it makes the judge and the lawyer into witch doctors and priests, and government into a religion, because now you have to trust them instead of your own understanding. And another thing we might add is that it turns a society of law into a society of men, because now the priests and the witch doctors, called lawyers and attorneys and judges, are the only ones who can interpret the law, and they can color that interpretation with whatever they want. And they will always color it in a way that financially benefits them personally, in violation of their oath, in violation of the Constitution, and the consequence is a criminal theft of your private property. We call it theft by presumption. Definitions are important. If a word is defined in the law, then you can safely conclude that you cannot rely on the common definition or the definition found in the dictionary, or it wouldn't have been defined in the law to begin with. Very important. And here's the Supreme Court on this subject. Stenberg versus Carhart, 530 U.S. 914, 2000. When a statute includes an explicit definition, we must follow that definition, even if it varies from the term's ordinary meaning. Meese versus Keene. It is axiomatic that the statutory definition of the term excludes unstated meanings of that term. And Collaudy versus Franklin, as a rule, a definition which declares what a term means excludes any meaning that is not stated. Western Union Telegraph Company versus Lenroot, Voss versus Standard Oil. See also Volume 2A of N. Springer's Sutherland on Statutes and Statutory Construction, Section 47.07, page 152, and Note 10, 5th edition. That is to say, the statute, read as a whole, leads the reader to a definition. That definition does not include the Attorney General's restriction, the child up to the head. Its words, substantial portion, indicate the contrary. So what they're trying to say when they say the statute's read as a whole, if one section of the code defines a word like income, then that word is limiting upon the entire code until there is another section identified that expands or modifies that meaning. And so if anybody wants to add a thing or a class of thing to a definition that does not appear in that definition, they have to point to another section of code that adds the thing they want to add. And if they don't observe that constraint, then in effect the law ceases to function in its only intended capacity, which is to define and limit government power. And at that point, if they can add, if they don't observe that rule of statutory construction, they can add whatever they want to a definition and include whatever they want and steal from anybody. And more particularly, what they will try to include is private property not subject to their jurisdiction and make it look like it's subject to the code, and it's not. And an example of private property would be a human being who is not a public officer in the government. That human being would not be a person or an individual, and therefore could not be subject to the code. And if they're not a person or an individual, they couldn't be anything else in the code, such as a non-resident alien or individual or an alien individual. You have, before you can be a non-resident alien individual, you first have to be an individual. Before you can be a foreign person, you first have to be a person. So, you cannot be anything in the code if you aren't first a person or an individual, and that individual, as we described earlier, is a public office in the government and not a private human, because, as we said, the ability to regulate private conduct is repugnant to the Constitution. And here's the other statement the Supreme Court on this subject. It is axiomatic that the statutory definition of the term excludes unstated meanings of the term, Collodi versus Franklin. Congress's use of the term propaganda in this statute, as indeed in other legislation, has no pejorative connotation. As judges, it is our duty to construe legislation as it is written, not as it might be read by a layman or as it might be understood by someone who has not even read it. So you cannot apply ordinary language to a statutory words. You first have to use the statutory definition, and that definition is all inclusive until they produce some statute somewhere that expressly includes those things that they want to include. And a good example would have been Section 6331 of the Internal Revenue Code earlier, where we showed that the levy can only be made on essentially instrumentalities of the government. Nowhere within that statute is included a private human or a private company. And in fact, the IRS Internal Revenue Manual specifically states that private employers are not required to enter into agreements with the government and therefore are not subject to the code. So this is just more proof of that. And they try to hide that fact. They try to cloud the separation between public and private. They try to make everything look like it's subject to their jurisdiction, but very little actually is. And that very little includes only officers, instrumentalities, and employees of the government, and contractors and agents of the government. That's it. So here are some definitions, some geographical definitions found in the code, and the various contexts that they can be found in. And keep in mind that a very important concept of definitions is that the meaning of those words depends on the context, and there are lots of different contexts. And we've listed the contexts across the top. The federal constitution, the federal statutes, the federal regulations, the state constitutions, the state statutes, and the state regulations. So those are all of the contexts that a word might be used in. And across the top in the columns. And then on the left are the actual terms. So first we list the author. The federal constitution is authored by the Union states, we the people, and the federal statutes and federal regulations are authored by the federal government. The state constitution is authored by we the people within that state, and the state statutes and state regulations are authored by the state government. The term state, quote unquote, in lowercase means, in the federal constitution, means a foreign country, and in federal statutes means a union state or a foreign country. And in federal regulations, it means a union state or a foreign country. So the capitalization of the word determines who it's intended for. If it's an all caps word, then and it's geographical in meaning, then it can only apply to those who are part of the sovereign, meaning the national government, if it's a federal statute. And so if it's lowercase, then it's not part of that sovereign, which means it's foreign, legislatively foreign. It's always foreign if it's lowercase. It's always domestic if it's uppercase. And so a union state or a foreign country fit in the same category if they're referred to as a state by the Supreme Court or in federal statutes. And this is a very common thing that you find in the statutes and the regulations. You'll see that. And they're very particular about the capitalization they'll use for the words, and especially in the definitions because of that. State constitutions, a lowercase s state means an other union state or the federal government, because both of those are legislatively foreign with respect to that jurisdiction. And the lowercase state means, in state statutes, means another union state or federal government, same all the way across. And a capital S state, on the other hand, is different. In the Constitution, it means a union state, a state of the union. But in federal statutes, it means a federal state, meaning a federal territory or possession, found in Title 48 of the U.S. Code. So they're completely different. So you can see that the meaning changes based on the context. Okay, and what you frequently find is that the union states are trying to be confused with federal states, and they'll say that the state used in the code refers to both of them. And that's just a presumption, because nowhere is it ever defined that way. Nowhere have we ever found in terms of Title 26, for instance, has the capital S state ever been defined to include a state of the Union. It never is, because Congress has no legislative jurisdiction there, and the reason is because of the separation of powers doctrine between the states and the national government. There's a separation of powers that's the foundation of the Constitution, and because they're separated, they are foreign with respect to each other. And because they are foreign, then they are everybody in the then states of the Union at that point are outside the jurisdiction of the national government for the vast majority of issues. And the only exceptions, some would say, would be things like Article 1, Section 8 powers. But the definitions clearly point out that those powers are limited to federal states and federal capital S states, meaning territories and possessions, instead of states of the Union. So read the definitions. Capital S state in state constitutions is a union state, and state statutes is a union state and union state. So another phrase you'll find in statutes is, quote, in this state, unquote, or in the state. And you find that most often in state statutes. And in state statutes, it means a federal enclave within the state. So, for instance, a national park would be the only thing that would fit within that description. And by the way, that national park is federal territory, and it's subject to the laws of Congress. And most state income taxes only apply in that area, federal enclaves. They don't apply within land within the exclusive jurisdiction of Congress. And what they try to fool people in the constitutional states into believing is that they are within a capital S state found in federal law, and they're not. And that's a violation of the separation of powers, and it's done specifically so they can steal and commit treason from people within the state's union. The other thing you'll find is capital S state in the state revenue and taxation codes, and that means, as we said, a federal enclave within the state. It doesn't mean land within the exclusive jurisdiction of that state government at all. And that's why most states have two different entities that they represent. They will refer to themselves as like Alabama or the state of Alabama. The state of Alabama is the federal state, meaning the collection of federal property within the state, whereas Alabama proper is a constitutional rather than a state, and therefore is not subject to the laws of Congress. So every state, just like every person, has two components to it. It has a public identity as a federal state within the state, within the federation of states, which is subject to federal law, and then it has a private identity as a constitutional state that is not subject to federal law. So, and just like people have both a public identity and a private identity. The private identity is your Christian name, and the public identity is your all caps name in association with a taxpayer identification number or social security number. Those two together identify an office, a public office, a franchise that you occupy, which is subject to federal law. And we would argue that you should never volunteer for such a franchise. You should never participate in it, that you will lose all of your constitutional rights when you do it, and that it's very damaging to your freedom if you do that. Another phrase you'll see is several states. In the federal Constitution, it means union states collectively. In federal statutes, it means federal capital S states collectively, meaning territories and possessions. So they're different. And same thing for all the state constitutions and state regulations. United States, quote unquote, means states of the Union collectively in a geographic sense within the federal Constitution, but it means the federal United States, **, meaning federal territories and possessions, and not the Union states in the federal statutes and the federal regulations. And same thing basically for the state constitutions and state statutes as well. So context is everything. Always think context, context, context. And if you're reading court cases, it's a very frequent tendency of judges to try to confuse the context. So they'll think so that they can fool you into thinking that they're enforcing within a constitutional state, so that they can evade liability for their torts, their treason of the Constitution. So you should pay very close attention to the context that they're talking about. And if you don't know what it is, you ought to ask them. And better yet, before the court action commences, you should define all the terms and the context in which they're used, And we actually have a form to do that. It's called the Federal Pleading and Motion Attachment. And you can attach that to your initial pleading in any court, whether it's a response or original petition, to define all the terms, to ensure that they can't play any of these word games, so that they have no jurisdiction essentially, because all their jurisdiction comes from the abuse of words of art and the fog and vagueness that they create. And that fog and vagueness can only be created with your cooperation. And by cooperation, we mean it can only be facilitated and protected with your legal ignorance. If you read the law, if you know your rights, then you cannot be deceived in that way. So it's very important to learn the law, and that's why we're teaching you here. So how laws are made. It is important to understand how our laws are made. The best resource for understanding this area is the pamphlet, How Our Laws Are Made, available on the Family Guardian website at the link provided. The procedure to pass and publish a new law is as follows. Item 1. Congress passes a statute or a public law based on authority delegated through the Constitution. It is published in the statutes at large, as we said earlier. Then, step 2, the Law Revision Council of the House of Representatives in the legislative branch then codifies the statute within the U.S. Code organized by subject matter. And number 3, an agency which is charged with executing the codified law then writes regulations to implement the codified statute. These regulations are then published in the Code of Federal Regulations. And step 4, if the statute is also intended to affect the general public in states of the Union or territories of the United States, then it must be enacted into positive law and have implementing regulations written for it that must also be published in the Federal Register. Without publication of the implementing regulations in the Federal Register, a statute may only affect public federal employees, federal agencies, benefit recipients, and the military. See 44 U.S.C. 1505A and 5 U.S.C. 553A. And item 5, if a violation of the law occurs, the courts must apply both the statute and the regulation that implements it to the specific controversy and thereby determine the rights and status of the parties. Absent an implementing regulation, they may not enforce a law against an offender. And we might add that this last item, item 5, is very important because in most cases, whatever it is the IRS is trying to enforce falls in this category, and it's unenforceable against the average American. And the only reason anybody thinks that it is enforceable is because they've been deceived. Precedents and hierarchy of law. There is a precedence of law within the legal field. Some laws take precedence over others. It is important to understand this precedence when there is a conflict, for instance, between a regulation and a statute. Items within higher precedents are used to resolve the conflicts. The precedence is as follows. The lowest number has the highest priority. The Constitution of the United States, the statutes at large, from which is written the U.S. Code, from which is written the Code of Federal Regulations, from which is written the Supreme Court rulings, the Circuit Court rulings, and the District Court rulings. The application is that when a regulation is broader than the statute it implements, then it is invalid and unenforceable. So if a regulation adds to the definitions, for instance, then it's invalid and unenforceable. It cannot add anything to the definitions. And when a district court ruling conflicts with a precedent established by a circuit court or the Supreme Court, then the higher court precedents rulings prevail. So the Supreme Court trumps the district court, which the circuit courts, which then trumps the district courts. And when the statutes at large contain a law that is in conflict with the Constitution, then the Constitution prevails and the law is invalid and unenforceable. For further information, see Precedents of Laws on the Family Guardian sister site. Force and effect of law is another very important subject. All of the items discussed in the preceding slide entitled Precedents of Laws have the force and effect of law. Certain government statements, publications, and advice do not have the, quote, force and effect of law, unquote. You should not rely upon any legal authority as a basis for good faith belief or compliance that does not have the force and effect of law. And examples of sources that do not have the force and effect of law and should not be relied upon to sustain a belief or a position, at least in the case of taxes, includes the procedural regulations, 26 CFR Part 601, as we said earlier, and this has been confirmed by the court cases of Einhorn versus DeWitt, Luring versus Glotzbach, And the Internal Revenue Manual, U.S. versus Will 671 F2D 963, says you can't trust any part of that. So it's not a good basis for a belief. It doesn't have the force of law. And all IRS publications and forms, see the Internal Revenue Manual, section 4.10.7.2.8. You can't trust any of those. So our question to you is, why the heck are you signing those things under penalty of perjury if even the IRS won't take responsibility for their accuracy? Hello? It's insanity. And the statements of IRS employees are telephone advice from the IRS employees. And the courts have confirmed this in Boulay versus CIR, 810 F2D 209. See the following link for further information about sources you can't trust. Here on the Family Guardian Sister site. So the fact that somebody, we want to emphasize here that the fact that somebody says something is law could itself be fraud. An example, if the entire Internal Revenue Code is not positive law, then it's a prima facie evidence. And if it's prima facie evidence, it's a presumption. And if it's a presumption, then it does not establish any obligation on your part because it violates due process of law. And the only way to overcome that presumption is for the government to produce evidence that you consented to it, and thereby it caused it to acquire the force of law. So in most cases, the entire Internal Revenue Code is being misrepresented as having the force and effect of law. Now, we're not suggesting that it doesn't have the force and effect of law against everyone. We're simply saying it doesn't have the force and effect against anyone other than public officers in the government, which is what a taxpayer is defined as. So you can call it law if you're a public officer, but you cannot call it if you want because it has the force of law. But you cannot call it law if you're not a public officer or an instrumentality of the government. And it's fraud to call it law because a law, by definition, is something that isn't required to have your consent in order to be enforceable. And if you have to volunteer to be a public officer first, then that's an act of consent, and therefore it's not law if you're not a public officer, period. It's not law for you, but it is law for public officers, meaning it has the force and effect of law. And an easier way to avoid this disparity is to simply call the code what it is and what the IRS calls it, the code or the Internal Revenue Code. And to call it code doesn't mean that it's law. So you should kind of avoid ever calling it law and argue with everybody who does call it law and insist that they prove that it's law. And that it applies to you whether you consent or not, because it doesn't if you're not a public officer. Positive law. Positive law is defined as law actually and specifically enacted or adopted by proper authority for the government of an organized jural society. So if the Internal Revenue Code was never enacted into positive law, then it's really not enacted or adopted for the jural society. And therefore it can only apply to the subset of that society that it was intended for, which is public offices. And a Supreme Court calls law that does not apply generally to everyone. The Supreme Court calls that class legislation. That's what they called it in the very first income tax that was declared unconstitutional in the case of Pollock versus Farmers Loan and Trust. That income tax was declared unconstitutional, and the Supreme Court in that case called it, quote, class legislation, unquote, which means it doesn't apply generally to all. It only applies to a subset of all, and that subset is public officers in the government. And that condition hasn't changed since then. The current Internal Revenue Code is class legislation because it only applies to public officers in the government. And when you think about it, that makes a lot of sense because the 13th Amendment applies everywhere, including federal territory, and it prohibits involuntary servitude. And the Internal Revenue Code essentially steals your labor. That's what wages are. They're a representation of your labor. It steals your labor. And if involuntary servitude is prohibited everywhere, including federal territory, then something sneaky must be going on. And that sneaky thing is that the tax is upon the office and not the officer, and the term wages, unquote, quote unquote, is earnings from the office. It's not earnings of a private human being, not engaged in an office. And that's why the W-4 says in the upper left-hand corner, employee withholding allowance certificate, because it can only be used by employees, and we already described what those employees are. they are officers and individuals within the U.S. government per 5 U.S.C. 2105A. The U.S. Code is organized by subject into 50 titles. Title 8 covers aliens and nationality and is positive law. Title 18 covers crimes and criminal procedure and is positive law and therefore evidence of an obligation. And Title 28 covers judiciary and judicial procedure and has been enacted into positive law. When U.S.C. Section 204 identifies which titles of the U.S. Code are positive law under the notes, and Title 26 covers the Internal Revenue Code, and it is not positive law. So, as we said, if it's not positive law, it's not legal evidence, and it's just a presumption. The entire title is a presumption. And as a presumption, it can only be quoted against people not protected by the Constitution because presumptions are a violation of the due process of law, and so on. Laws which may be enforced by the federal government in states of the Union or federal territories must be positive law and must have implementing regulations published in the Federal Register. Otherwise, they apply only in the District of Columbia to the federal employees, benefit recipients, federal agencies, and federal contractors. And this is proven in 44 U.S.C. 1505A, 5 U.S.C. 553A, if you want to look at it. We even provide a link, and requirements for reasonable notice, Form 05.022. Moving on, Internal Revenue Code Subtitle A is a religion for people in states of the Union. IRC Subtitle A is a law for public officers, domiciled in the District of Columbia, but a religion for everyone else, including states of the Union. Why do we say that? Because it cannot, if it's not positive law, it cannot have the force of law for those who are not domiciled on federal territory and therefore not protected by the Constitution. Due process of law requires that presumptions cannot supersede the protections of the Constitution. And if the entire title is a presumption, then it must be unconstitutional in a state of the Union, and therefore only constitutional where the Constitution doesn't apply on federal territory or within public offices in the national government. A religion is simply any system of behaviors and convictions whose validity or authority cannot be proven or demonstrated scientifically and instead are a matter of personal opinion and belief. Such personal opinion includes those of federal judges, and which do not have the force and effect of law, and which operate exclusively by voluntary consent and participation, and which are an extension of our right to contract, where we voluntarily and without duress surrender our natural rights in exchange for some perceived public or personal good, whether it be spiritual or economic. We define a religion as, and the Black's Law Dictionary for that matter also defines a religion as any system in which supernatural beings are worshipped. And worship is essentially obedience to the laws and dictates of a supernatural or superior being. Here's the definition right from Black's Law Dictionary, quote, religion, man's relation to divinity, to reverence, worship, obedience, and submission to the mandates and precepts of supernatural or superior beings. In its broadest sense, includes all forms of belief in the existence of superior beings exercising power over human beings by volition, imposing rules of conduct with future rewards and punishments, bond uniting man to God, and a virtue whose purpose is to render God worship due him as source of all being and principle of all government of things. And that would be Nikulnikov versus Archbishop, etc. of Russian Orthodox Greek Church, 142 MISC 894. And that was from Black's Law Dictionary, 6th edition, page 1292. So, a religion essentially is the worship of supernatural or superior beings. And anyone who claims to have rights above and beyond that of the natural human being, a man or a woman, is supernatural. And so if they claim a right over you that you don't have, or if they claim to have a power that was delegated to them that didn't come from you or couldn't come from you, then they're exercising supernatural powers. And those supernatural powers, the purpose of those powers is to make you unequal in relation, that is the worshiper, unequal in relation to the worshipped, which is the God or the supernatural being. And worship means obedience. And notice in this definition they talked about the rules of conduct. Well, those rules of conduct are called franchises. civil statutory franchises to be precise, and the Internal Revenue Code is one of those. So the purpose of that code is to create inequality between the governed and the governors, and to steal from people, and to call it worship, or to associate it with an obligation of being a citizen. And a citizen really in that context is nothing more than a parishioner of a state-sponsored church, we might add. So, moving on. Because the Internal Revenue Code Subtitle A has no liability statute on anything other than withholding agents on non-resident aliens in 26 U.S.C. 1461 and imposes a tax on voluntary avoidable excise taxable activity in only the District of Columbia, then for people in states of the Union, it is a voluntary federal religion, and it is unenforceable and may not adversely affect the rights of people who have not voluntarily surrendered their rights by some legal mechanism, however devious. Only those legal persons who have voluntarily and ignorantly surrendered their rights in exchange for excise taxable privileges are the proper subject of Subtitle A Internal Revenue Code. These persons are privileged public officers and federal instrumentalities serving in a public office, see 26 U.S.C. 7701A26, 26 CFR 31.3401C-1, and 26 CFR 1.872-2F. These persons also include federal corporations established under federal and not state law and which are involved in foreign commerce only. See 26 U.S.C. 7001 and 26 CFR 1.861-8F1. And those who have submitted tax returns and assessed themselves, even if they are not in fact liable, under the religion called the Internal Revenue Code. And we might add that the payments under those conditions essentially are tithes to a state-sponsored church. And unfortunately, those tithes are far in excess of the 10% that most Christian churches would charge. So it's a more virulent religion than any other type of religion in that sense, because they try to claim over half of what one earns in some cases. And it also includes those not engaged in the trade or business, but who act like taxpayers by not rebutting false information returns filed against them, such as IRS Forms W-2, 1042-S, 1098, and 1099. See Income Tax Withholding and Reporting Course, Form 12.004. The reason that the Internal Revenue Code must be a religion and a voluntary choice for people in states of the Union is that because a free people must consent to the taxes they pay, and they must pay only those government services they desire and want. They cannot be expected to pay for things they don't want and don't need, or they are slaves. And, we might add that a slave is anybody who is put into the service of others. And the Declaration of Independence says that to secure these rights, governments are instituted, deriving their just powers from the consent of the governed. So the idea is that anything that does not derive directly from your consent is unjust. And if it's unjust, it's unlawful and unconstitutional. Slavery is under the 13th Amendment is a crime everywhere, including on federal territory. So they cannot compel you into servitude, and wages are just a representation of that servitude. If they tax your wages, they're taking away your service, your labor. And the Supreme Court has said in the Antelope that they're not allowed to do that. So obviously there must be an intermediate status between the human and the taxpayer, which creates jurisdiction. And that status is a public office. A taxpayer is a public office. You have to volunteer into the office, and they'll try to fool you into thinking that you don't have to volunteer in order for them to have jurisdiction, but it's all fraud, and it's all smoke and mirrors. And we prove these things in Why Domicile and Becoming a Taxpayer Requires Your Consent, Form 05.002 on our forms page. And we also prove it in Requirement for Consent, Form 05.003. And the article entitled No Taxation Without Consent, which is actually on the Family Guardian sister site, and we didn't write that article. The free book below proves that the government has become a false god, a religion, and a cult in every particular. Socialism, the New American Civil Religion, Form 05.016, and that is written as a memorandum of law, and it's intended to be used in litigation against the government under the Religious Freedom Restoration Act to disestablish the state-sponsored religion established by the Internal Revenue Code. We describe the Internal Revenue Code as essentially the Bible of a state-sponsored church. The presumptions established by that prima facie code are the system of belief or faith, and the tithes paid under that religion are called taxes, and the unequal relationship between the governed and the governors is a religion, and the object of that religion is servitude toward those with supernatural powers, and the legal person who is the object of that worship is, quote, the United States, unquote, which is a federal corporation. So everybody's worshiping a federal corporation. And the worship is essentially instituted with those tithes to the religion. And commerce and all the unrighteous fornication that goes with it is the very same commerce that's described in the book of Revelations in the Bible, where Babylon, the great harlot, is described as a woman who sits on many waters, and the waters are described as nations, peoples, and tongues. And the fornication she's engaging in is commerce, because Black's Law Dictionary defines commerce as intercourse. And intercourse is the equivalent of sex. So uncle wants you to engage in a sexual relation with them. And that's the fornication described in the Bible book of Revelations. And you can't engage in that fornication without being numbered and accepting the mark of the beast. And that's why the first bowl judgment in the book of Revelations is upon those who took the mark, because you cannot engage in the fornication without taking the mark and being essentially Caesar's property instead of God's property. And remember, if the Bible says that the heaven and the earth belong to the Lord's and that he created them all, and the creator of a thing is the owner of a thing, then essentially what Caesar is doing is renting out God's property. He's renting out property that doesn't belong to him. He's renting out stolen property, and anybody that allows Caesar to do that is essentially money laundering and engaging in a conspiracy to destroy religious property, because the entire earth and the heavens are religious property and they belong to God. Legal research. The Family Guardian website has many resources to help you do further legal research and validate everything we are saying in this website. And you can find those resources on our legal research sources link, which is actually on the Family Guardian site, or in the State Legal Resources link on the Family Guardian sister site, or Law and Government on the Family Guardian sister site. Third-party resources to do your own legal research. Cornell University Law has the complete U.S. Code, and Versus Law has lower court rulings. And that's a subscription service, which is available for a pretty low fee for legal neophytes. And we admonish you, don't take our word for it or assume anything we say is factual. Study the law for yourself. And Proverbs 28:9 in the Bible explains why. Quote, one who turns his ear from hearing the law, even his prayer, is an abomination. So it's your job to learn the law, because the law is, as the Apostle Paul said, is a schoolmaster to teach us how to love our neighbor and how to protect our neighbor. So that's the reason to learn the law. And learning the law doesn't mean we're pharisaical. It doesn't mean we're legalistic. It simply means we care about how to love our neighbor. And we might also add that if you don't care and you don't study the law, you're not only not going to protect your neighbor, but you yourself will also become a slave to Caesar. So you really don't have any choice. You have to study the law if you ever expect to be free. So let's do a summary of the citizenship and sovereignty concepts found in our Citizenship and Sovereignty course. A brief review. A constitutional, quote, citizen of the United States, unquote, is described in the 14th Amendment, is not the same as a statutory citizen of the United States described in 8 U.S.C. 1401, because the term United States has entirely different meanings in these two mutually exclusive contexts. You cannot simultaneously be a constitutional citizen domiciled in a state and a statutory citizen under federal law domiciled on federal territory, because you can't be in two places at once. And domicile is the only way you can have a status in either one of those two places, and you can only be domiciled in one place at a time. People born anywhere in America and domiciled in the exclusive jurisdiction of the states of the Union are nationals but not citizens under 8 U.S.C. 1101A21. They are not statutory citizens under the Internal Revenue Code. See, you're not a statutory citizen under the Internal Revenue Code. And they are not residents under the Internal Revenue Code. See, you're not a statutory resident under the Internal Revenue Code. And a national of the United States, star, 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 meaning states of the Union and not federal territory, who is not a statutory citizen, is a non-resident, but not a non-resident alien individual under the Internal Revenue Code. See 26 U.S.C. 7701B1B. The terms alien, resident alien, and resident are all synonymous within the context of the Internal Revenue Code and mean alien. And we also emphasize that a statutory alien and a constitutional alien are not the same thing. You can be a person who is not born or naturalized in the United States and be a constitutional alien, meaning a foreign national, and yet at the same time, you would also be an alien under the Internal Revenue Code, but you could also be a constitutional citizen under the Constitution and be an alien under the Internal Revenue Code. Why? Because the term United States is geographically defined in 26 U.S.C. 7701 A9 and A10 and 4 U.S.C. 110D as federal territory that is not within any state of the Union. And so to say that you're a citizen of that United States means that you're not a citizen of a state, because the geographical contexts are mutually exclusive. And as we said earlier, context is everything. You should always pay attention, very close attention to the context of every word of art, and especially geographical word of art used in the codes. Next, we're going to show you a sequence of diagrams and tables that will help reveal the relationship between domicile, nationality, and your civil status. Domicile, we said, was the origin of your tax liability. Domicile is something that only you can choose, and it must be voluntary. And hence, the tax liability itself must indirectly be voluntary. Notice that we didn't use the word citizenship because that word is often abused to confuse whether they're talking about nationality or domicile, and especially by the government in court. The federal courts have ruled that citizenship itself, in fact, is equal to domicile in federal court. What you have in front of you is a diagram. The top of the diagram shows those who are non-residents, meaning those who are domiciled within states of the Union or foreign countries, and the bottom half of this diagram shows inhabitants who are domiciled within federal territory within the statutory but not constitutional United States. Non-residents can transition to inhabitants and thereby become taxpayers by changing their domicile and thereby crossing the line to the bottom. There are two primary groups of both non-residents and inhabitants. The first group is nationals, people who are members of the nation by virtue of their birth or naturalization, and the other group are aliens, who are people who were not born or naturalized in the country. And those two groups are shown both on the top and the bottom. And you can transition from a non-resident national to a resident national by crossing the line using the arrows provided. We show how your status is changed to effect that change in civil status and the forms that you would have to file to cross. And likewise, foreign nationals born in foreign countries can transition to becoming resident aliens by changing their domicile to the federal zone. And they do that by declaring a declaration of a domicile to within the United States under 26 CFR 1.871-4. And while they're domiciled on federal territory, they can change their domicile back to be outside the United States and thereby lose the tax liability under 26 U.S.C. 7701 N2 and 26 U.S.C. 6039G. So these people would be resident aliens if they're domiciled on federal territory, and they're described in 26 U.S.C. 7701B1A, or aliens, 8 U.S.C. 1101A3. And when they become non-residents, they turn into basically non-residents, one of two types of non-residents. You can see everybody on the top here is identified as either, there's a box around both groups, and everybody's identified either as a non-resident alien, 26 U.S.C. 7701B1B, if they're public officers, or non-resident non-persons if they're exclusively private. Whereas on the bottom, there's a similar box, and all these people are collected, both resident aliens and resident citizens of the United States, ***, meaning federal territory. Both of those groups are called U.S. persons, 26 U.S.C. 7701A30. So you can only be one of two things: a U.S. person and a taxpayer down here, or a non-resident up here. And you can be one of two types of non-residents: non-resident non-persons, meaning you're not subject to the civil statutory law because you have no contracts or agency in place with the national government and no domicile; or a non-resident aliens, 26 U.S.C. 7701B1B, if you're a public officer. Now within the nationals box up here, 8 U.S.C. 1101A22B, these people are non-citizen nationals, and they're non-citizen nationals because you cannot be a statutory citizen without a domicile on federal territory. So if you're not domiciled there, then you're simply a non-citizen national. And you would be described in 8 U.S.C. 1101A22B. Now that particular statute does not specifically say non-citizen national. Instead, it says persons who are not citizens but who owe allegiance to the United States. And that United States is a political entity and not a territorial entity. And if you look at the definition of national in Title 8 at 8 U.S.C. 1101A21, a national is defined as a person owing allegiance. So obviously, in 8 U.S.C. 1101A22B, they're talking about people who owe allegiance, meaning who are nationals, but who are not citizens. So they're really describing non-citizen nationals, but they're not describing necessarily the subset of non-citizen nationals called non-citizen nationals of the United States. Those people are basically born and domiciled within federal possessions, such as American Samoa or Swains Island. So there are two groups of non-citizen nationals up here. And the first group is constitutional citizens and nationals of the U.S., ***, meaning United States of America, meaning states of the Union. And they're described in 8 U.S.C. 1101A21 and the 14th Amendment. And the other group of non-citizen nationals are the non-citizen nationals of the U.S., ***, meaning federal territory, at birth. And they're described in 8 U.S.C. 1408 and 8 U.S.C. 1452. But notice that these two groups up here of non-citizen nationals are born outside of the federal territory. And so the IRS Form 1040-NR even has a block to describe these people as non-resident aliens. It specifically lists people in the possessions of American Samoa and Swains Island as being U.S. nationals. But constitutional citizens / nationals born and domiciled in states of the Union technically would not fit the classification under 8 U.S.C. 1408 or 8 U.S.C. 1452, but they would in a generic sense be referred to as non-citizen nationals, 8 U.S.C. 1101A22B. So you can see that if you started out in a state of the Union, you're born there and you're domiciled there, and then you file a IRS 1040 and or W-4, then effectively you will at least appear to be a resident alien. If you don't physically change your location and you don't physically move to federal territory, but you file those forms, technically you're committing the crime of impersonating a public officer if you didn't start out as a public officer before you filed them. And likewise, you can change your effective domicile or residence to be a non-resident if you started out as a statutory citizen of the United States, and you can go back to, and you notice it points to the box in the outside box, the non-citizen national box. The arrow here points there instead of the individual constitutional citizens, because that means both of these non-citizen national groups can go down to become statutory non-citizen nationals. Now, the other interesting thing down here on the bottom is these people are nationals also, just like the two groups up there, and the box is the same size because it encompasses both of those groups. But notice there's only one box, and that would be national and citizen of the United States ***, meaning federal territory, at birth. And notice the end of that name, at birth. They can only define the status of people who are born on their territory. Otherwise, they're non-residents, and they cannot legislate for non-residents at all. And that would be determined under state law instead. But these people are described in 8 U.S.C. 1401 and 26 CFR 1.1-1C, and they're born in U.S. territories. And notice that they are a subset of statutory, quote, citizens of the United States ***, close quote, meaning federal territory. Now, these people, on the other hand, are described in 8 U.S.C. 1101A22A. And the other interesting thing here is that if either one of these two groups up here of nationals changes their domicile to federal territory, notice there's an arrow pointing down from each one, then essentially they become statutory citizens of the United States, but they would not be national and citizen of the United States at birth, 8 U.S.C. 1401, because they were not born on federal territory. So, but they can still change their status by changing their domicile and their physical location. And when they do that, for instance, a state citizen would change his domicile by filing IRS Form 1040 and W-4, and then he would move back down to this box and be a statutory citizen of the United States subject to the exclusive jurisdiction of Congress at that point, but only if he changes his physical location. And likewise, he can change it back by refiling the forms to use non-resident forms. And same thing for statutory non-citizen nationals of the U.S. ** at birth, federal territories and possessions. They can do the same thing as a state citizen. Now, between the group of nationals on the left and aliens on the right, there is a process to transition between those two groups. So a national can expatriate. Expatriation is defined as the loss of nationality. And notice that the word nationality has the root word of national within it. So if you expatriate, you abandon nationality and allegiance under 8 U.S.C. 1481, and you become a foreign national or a national of a foreign country. And likewise, a national of a foreign country can be naturalized under 8 U.S.C. 1421 and become a national. And the same thing happens down here on the bottom. So depending on your domicile, your status will change. Now, a lot of people in states of the Union mistakenly refer to themselves as statutory citizens of the United States. And in fact, they are not unless they're physically present on federal territory and they're domiciled there. And if they're not, then they cannot file the IRS Form 1040 or the W-4 unless they're engaged in a public office, obviously. And that creates a lot of problems for most Americans, in fact, is that they're filing the wrong tax forms. The 1040 form is a resident tax form. It's not a non-resident tax form. The 1040-NR is the non-resident tax form. So if you're on the top up here, you cannot file a resident tax form. You have to file a non-resident tax form. And even then, you should not file even a non-resident tax form on the top unless you are acting in a public capacity as an agent or officer of the national government, because Otherwise, you would be private. And the ability to regulate private rights and private conduct is repugnant to the Constitution as held by the Supreme Court, and therefore you wouldn't need to file any tax forms if you're on the top and you're not lawfully engaged in a public office and or a public activity. We remind our listeners that in fact the income tax is a excise tax upon the public office franchise owned by Uncle. And so it's a tax on the office, and the taxpayer in fact is the office, and the officer filling the office could be a non-resident up here, whereas the office itself is always resident down here. So the 1040 form, the resident tax form, in fact is a profit and loss statement for the office and not the officer. The only thing that can go on here is the 1040 form that you'd file down on the bottom is public activities of public officers on official business and all property donated to that business by using the Social Security number. Next, we've prepared a table that shows all the permutations of both citizenship status, actually nationality here in this second to the left column, nationality, and the place of birth describes your nationality, and the domicile. So for any given nationality in this column, you can have multiple domiciles. So we've gone through all the permutations of domicile to show you how they interact with each other. So, and then on the right, we have all of the tax statuses under 26 U.S.C. Internal Revenue Code. And there are 4 possible tax statuses for a human being. So we list columns to show you which status in the Internal Revenue Code that each person has based on their nationality and or domicile on the left. And we also have a column here for treaty benefits. A treaty benefit is essentially a franchise, and the acceptance of the benefit of a franchise causes the accepting party to be treated as if they are a public officer and therefore subject to the laws of Congress. And so as we tell people, you should never participate in any government franchise, never accept any benefits of the franchise. As a matter of fact, you ought to use franchises against the government to defend yourself, so you never become party to their franchises. And then the last column on the left over here, before we hit the tax status, is the Title 8 status that this person would have. So the first row here is national and citizen of the United States * at birth, which is defined in 8 U.S.C. 1401. They are born in the statutory United States, federal territory. They have a domicile on federal territory, and they're not accepting a treaty benefit because you can't have a treaty within the country. You can only do it outside the country. And those people would be treated as citizens under the Internal Revenue Code. So, and that status would be described in 26 CFR 1.1-1, C to be precise. And the next type of party that we talked about earlier in the previous page is a non-citizen national of the United States * at birth. And those people are born in basically American Samoa, Swains Island, or abroad to U.S. national parents. And they, right here. And they're also domiciled if they don't move in American Samoa and Swains Island, which are U.S. possessions. And they're not accepting treaty benefits because those are possessions and you can't do treaties in the possession. And they're described in 8 U.S.C. 1408 and 8 U.S.C. 1101A22B and 8 U.S.C. 1452. And these people are treated essentially as resident aliens. They're treated as non-resident alien individuals down here. But just as we said, an individual is always a public office. And so the only way they'd be an individual is if they're engaging in a public office or contracting with Uncle. Otherwise, they wouldn't even be non-resident alien individuals. They would be non-resident non-persons if they're not engaged in a public office. So the next page, the next status, status 3, is people who are born in states of the Union here in this third column. And they're described as statutory non-citizen nationals or USA *** nationals, meaning federal union states. And they're domiciled in a state of the Union. That's the first option we've covered here. They're not subject to treaty benefits because treaties don't apply within states of the Union. They're described in 8 U.S.C. 1101A21, 8 U.S.C. 1101A22B, and the 14th Amendment. And they would be treated as non-resident non-persons if they're not engaged in a public office. If they are engaged in a public office, they would transition over to non-resident alien individuals. And likewise, if they then change their domicile from a state of the Union here down to a foreign country, then they would basically be non-resident alien individuals because at this point they're accepting a treaty benefit. And the benefit is a franchise, and franchises presume the beneficiary is a public office. And they're described in the same statutes. And if they then abandon the treaty benefits in the foreign country that they're domiciled in, then they would be non-resident non-persons, not subjects. So they don't even have to file even a non-resident tax form at that point. And then the fourth option for state citizens would be they're born in a constitutional state, but then they change their domicile to Puerto Rico, Virgin Islands, or Guam, or the Commonwealth of Northern Mariana Islands. And at that point, they would become citizens, statutory citizens, subject to the exclusive jurisdiction of Congress. So simply by physically moving to federal territory, they would be treated as citizens under 26 CFR 1.1-1. So they would go from non-residents to basically domiciliaries, and domiciliaries includes residents and citizens, and they would be a privileged statutory citizen simply by virtue of their domicile and physical presence on federal territory at this point. And then the fourth option is, item 4 here, is foreign nationals, people born in foreign countries. And they have one of 5 possible domiciles. They could be domiciled in a federal territory, and they would be defined at that point in 8 U.S.C. 1101A21 and 8 U.S.C. 1101A3. And they would be treated as resident aliens because they're domiciled on privileged territories, resident aliens, and all resident aliens are individuals. So they would be individuals, and so they would be presumed to be public officers as individuals. And if they then change their domicile to a state of the Union, but they accept the treaty benefit, they're still engaged in a franchise, so they're still individuals, but now they become non-resident alien non-individuals, or I'm sorry, individuals, because they are domiciled in the country and they're accepting a treaty benefit. And the benefit causes them to be treated as if they are public officers. And likewise, if they abandon the treaty benefit here, then they would become non-resident non-persons, and therefore not public officers, and therefore exclusively private. Everything in the non-resident non-person column is exclusively private. If they then change their domicile back to the foreign country they came from, or any other foreign country, but they accept the treaty benefit there, then they would be non-resident alien individuals if they receive trade or business earnings, which are public office earnings. And why? Because they're engaged in the franchise. Treaty is a franchise. And if they abandon the treaty benefits, then they would be non-resident non-persons again. So you might want to go back over this chart. It's very important to see how all the various factors, the place of birth, your physical domicile, whether you're accepting treaty benefits, interacts with your tax status under Title 26 of the Internal Revenue Code. So next we're going to go over all the various definitions of United States, and these definitions were explained by the U.S. Supreme Court in Hooven and Allison Company versus Evatt, and we've enumerated them here, and we're going to use these enumerations in the following page to describe yet another diagram that shows you another way to understand the relationship between domicile, nationality, and your tax status. So here's what the Supreme Court defined federal statutory citizenship, the term United States. Quote, the term United States may be used in any one of several senses. It may be merely, number one, it may be merely the name of a sovereign occupying the position analogous to that of other sovereigns in the family of nations. Number two, it may designate the territory over which the sovereignty of the United States extends, and that would be federal territory. And or three, it may be the collective name of the states which are united by and under the Constitution. So all of these essentially are geographic terms. So don't confuse yourself. Now, there's also a fourth meaning as well, and that would be the United States as a government or a legal person. So there's actually 4 United States, but they only explain 3 of the geographical United States here. So US 1 is the context used in matters describing our sovereign country within the family of nations. US 2 is the context used to designate the territory over which the United States government is sovereign. And by sovereign, we mean exclusive jurisdiction. We mean plenary jurisdiction over federal territory and federal property. And US 3, the context used regarding the sovereign states of the Union, united by and under the Constitution. Now let's put the various federal citizenship statuses into a diagram to make their relationships crystal clear, starting on the next page. So once again, we have US 1, 2, and 3, which we just finished describing from the previous page. And now what we've done is we've drawn a Venn diagram. Each circle is a group. So the biggest circle is US 1, meaning US the country in the family of nations. So within US 1, we have 2 other groups. US 2, which would be federal territory and possessions on the top here. And then we have US 3, which would be states of the Union. So there are 3 US's, and the context, the geographical, that is 3 geographical US's, and the context of which US or United States is implied in any given statutory scheme is usually ambiguous and deliberately ambiguous so that you will not know what the limits are upon their jurisdiction. But the most important thing you can do is learn what those limits are. So you need to be very careful whenever you use that word, United States, and you need to put a star, or a star after that term every time you use it everywhere. And you should insist that everybody else does the same thing so you know which of the 3 they're talking about here. So US 1 would be US star, US 2 would be US star, and US 3 would be US star. And so now within federal territory and possessions, which is US 2 here, we have 2 groups, statutory, national, and citizen at birth. And notice both of these share the at birth phrase here within federal territory. So this would be what we call the statutory citizen. And these people are described in 8 U.S.C. 1401. They're domiciled in the District of Columbia and territories belonging to the U.S., Puerto Rico, Guam, Virgin Islands, and Northern Mariana Islands. And so these are statutory U.S. citizens. They're not the only statutory U.S. citizens, but they are the ones who are born on federal territory. And we'll explain that in a minute. And then these people are nationals but not citizens at birth. And they're always born in federal territories. They're defined in 8 U.S.C. 1408 and 8 U.S.C. 1452, and they start out domiciled in American Samoa and Swains Island. And then on the bottom we have constitutional citizens, and those people are described in 8 U.S.C. 1101A 21, the 14th Amendment, and the Law of Nations, and they're domiciled in the constitutional but not statutory states, quote unquote. Now, the really important thing here is all these little circles, okay? Because these circles classify all of these various birthplaces and nationality/domicile statuses with specific statutes, okay? So A statutory citizen at birth up here in the upper left circle, that person will be described in 8 U.S.C. 1401, and there's a circle 2 here. So they're described with a circle 2 here as well. And then circle 1 would be nationals, 8 U.S.C. 1101A21. Those are the people who are on the upper left corner on the previous diagram. And those people are described in right here with the circle 1. Now you might ask yourself, how come these people up here are not simply nationals? And the answer is 8 U.S.C. 1101A21 says that a national is someone owing allegiance to a state, and the word state is then lowercase, and lowercase means foreign. So the federal possessions are not foreign with respect to exclusive legislative jurisdiction of Congress, and neither are the federal territories. And so neither one of these two groups, statutory nationals and citizens at birth, or statutory nationals but not citizens at birth, neither one of those groups are legislatively foreign with respect to Congress. So they cannot have allegiance to a foreign state. Whereas down here, the constitutional states are sovereign and legislatively foreign, and therefore the people in those states would have allegiance to the people in their state, because the people in that state would be legislatively but not constitutionally foreign. And so they would be described as nationals, and they're the only ones, and that's why we have a 1 here. And then we have 8 U.S.C. 1101A22, national of the United States. And notice we put number 1 here. So, and we said it was a 3. So circle 3 here means that all of these people are nationals of the United States, because that United States is the country. So they're all nationals. They're all members of the political community within the circle numbered 3 here. Every one of them are nationals. Now you might ask, how come we would want to call ourselves anything that has the word United States in it as a constitutional citizen down on the bottom? And the answer is that United States is a political group and not a territory. It's a political entity. It is the sovereign, the only sovereign in our country. And we said that a national is somebody owing allegiance. So, and you can owe allegiance whether you're physically present on federal territory or not. There's nothing wrong with having allegiance to the political community of the collective states of the Union. In fact, the last 6 commandments of the 10 commandments require you to love your neighbor. And when you love your neighbor, you have allegiance to your neighbor. You want to protect your neighbor. So there's nothing wrong with having allegiance to the political group. And as a matter of fact, you cannot deserve protection unless you have allegiance. And we like to say that protection draws subjection, so you become essentially a subject of that community. That doesn't mean you're a subject to the legislation of Congress necessarily, because you can be a political member without being a legislative member or having a civil status under the laws of Congress. Next, we have circle 4 here, which is 8 U.S.C. 1101A22A, and we put it in quotes, citizen of the United States 2, or ***. So, and the 4 is right up here. So this is essentially a statutory citizen of the United States at birth, okay? But also, and we said that the 8 U.S.C. 1101A22A statutory citizens are a superset that includes statutory nationals and citizens at birth. Okay, so there actually are 2 circles here, and one of them should be those who are statutory citizens of the United States at birth, and the other circle would be, for instance, people who started out over here as constitutional citizens or statutory nationals but not citizens at birth, and who then changed their domicile to federal territory and then changed to citizens of the United States because of their domicile. Now and so that status would, but they were not citizens of the United States at birth, so they would not fit the description of 8 U.S.C. 1401, but they would fit the description down here of 8 U.S.C. 1101A22A. And lastly, we have Circle 5, which is 8 U.S.C. 1101 A22B, which is non-citizen nationals, and that is the circle appears here. So you can see that non-citizen nationals are described 8 U.S.C. 1101 A22B are shared. That status is shared between U.S. 3 and U.S. 2. So it's shared by possessions up here and constitutional states up here. The other thing is, if any one of these people are started out physically within the country and they change their domicile to a foreign country, then they would be described in this upper right circle here, and they would then become nationals because they changed their domicile, and their allegiance would be foreign because it's to a foreign government that they're temporarily being protected by, and their local allegiance, that is their domiciliary allegiance. And then we also have item 5 here, which is non-citizen nationals. So they'd be non-citizen nationals. They would not be statutory citizens of the United States here, which would be circle 4. This whole thing here is circle 4, and within circle 4 is essentially 8 U.S.C. 1401, which is circle 2. So these people would not be citizens of the United States, and of course, the only parties subject to the Internal Revenue Code are those who are citizens and residents. That's what a U.S. person is defined as in 26 U.S.C. 7701A30. So these people would not be citizens or residents over here, unless if they change their domicile to be outside the country United States. They would simply be transient foreigners and non-citizen nationals and non-resident non-persons if they're not engaged in business with Uncle and they're not operating as a public officer, because once again the Internal Revenue Code is a franchise tax upon public offices within the national government. Americans domiciled in states of the Union. People born in America and domiciled within a state of the Union are constitutional citizens, are not statutory citizens under 8 U.S.C. 1401. They are not statutory residents under 26 U.S.C. 7701B1A. They are non-residents, but not non-resident alien individuals. And they're not even non-resident aliens unless they're doing business in the United States and they're doing so as a public officer or representing a public office. Otherwise, they don't have any presence at all. They don't have any status under federal law. And that's equivalent to saying that they have to waive their sovereign immunity to become persons and individuals before they're subject to any of the enactments of Congress. And the minimal context doctrine in international shoe is the method for doing that. And that doctrine is also found in the Foreign Sovereign Immunities Act, 28 U.S.C. Chapter 97. So you can't acquire a status under the laws of a jurisdiction without either a domicile there or representing an entity that has a domicile there. And occupying a public office is an example of how to represent that entity. And people born in states of the Union are not statutory U.S. persons under 26 U.S.C. 7701A30. And here's the definition of that. United States person. The term United States person means a citizen or resident of the United States, and these are statutory citizens or residents, so they're domiciled on federal territory, not within any state. A domestic partnership, a domestic corporation, and by domestic they mean within the domicile, within the civil legislative exclusive jurisdiction of Congress on federal territory, or any estate other than a foreign estate within the meaning of paragraph 31, or any trust if a court of the United States is able to exercise primary supervision over the administration of the trust, and one or more of the United States persons have the authority to control all substantial decisions of the trust. So, the important thing to remember here is the term United States is geographically defined within all Title 26 and also within 4 U.S.C. 110D as being federal territory that is not any part of a state of the Union. So to say that they are a person within that geography is to say that they're domiciled there, that they're a partnership that's domiciled there, or a corporation that's domiciled there, or an estate that's being managed by one of those people, or a trust that's being managed by a U.S. person, or that they're not a foreign estate. And a foreign estate under 7701A31 is an estate that's not engaged in a trade or business, meaning a public office in the government. So if you're not engaged in a public office, they don't have any jurisdiction over you, which makes sense because they can only regulate public conduct and they have no jurisdiction over private conduct as held by the Supreme Court. The two types of non-residents. A non-resident alien is someone who is neither a citizen of the United States nor a national of the United States, meaning federal territory, under federal law. And here's the definition. Definition of a resident alien and non-resident alien. In general, for the purposes of this title, a non-resident alien, an individual is a non-resident alien if such individual is neither a citizen of the United States nor a resident of the United States. Now, the important thing to notice about this definition is that it's a non-definition. It defines what a non-resident alien is not. It does not define what it is. It says a non-resident alien is neither. It says it's neither this nor that. It doesn't say what it is. It says what it isn't. Okay, and the reason they did that is because if they defined what it is, then everybody would realize they're included and they wouldn't file tax returns. That's the first reason. Second, the second problem with this non-definition is that because it doesn't really define what it is and it only defines what it isn't, then there's no way you can look at this definition and conclude that anybody fits the description. The other important thing about this definition is that it defines whether an individual is a non-resident alien, but it doesn't define whether a non-individual can be a non-resident alien or a non-person or anybody other than an individual, such as, for instance, a corporation or a trust or a partnership. All of those are artificial entities, and they wouldn't ordinarily be regarded as individuals. And because they wouldn't be individuals, then the implication in this definition is that they can't be non-resident aliens either, but in fact they can. Because once again, they didn't define what it is, they defined what it isn't. And how do we know that? Because if you look on the W-8 form in Block 3, under the entity type, you'll see there are lots of entities listed there as non-resident aliens. And there are trusts and estates and partnerships and everything else listed there, and none of those things are listed under the definition of non-resident alien in the Internal Revenue Code, but they fall within the definition anyway. So obviously there are things that that may be non-resident aliens which are not even mentioned here. And in that sense, you could say that this definition is void for vagueness because it does not define what it is. It only defines what it isn't. So it's not really a definition. And so to say that you're a non-resident alien really is kind of an oxymoron because you don't really have any evidence to prove that you are. You can prove what you're not, but you can't really prove that you fall within the description of this. And so it's void for vagueness to begin with. The important thing, though, is that the term non-resident is included in the definition. So, and this is the only status that includes non-residents anywhere in the code, because a U.S. citizen and a U.S. resident is not included in the definition of a non-resident. So this is the only type of non-resident defined in the code, and it's not really even defined because it defines what it isn't and not what it is. So it's kind of an oxymoron, and it's kind of hypocritical to say that you even have this status of non-resident alien if they never really define it, now isn't it? And so that's why we say that's. And by the way, as we said before, you cannot be a non-resident alien without first being an individual. And there's no case where any duty is imposed upon non-resident aliens unless they're individuals. The duty to file a tax return, for instance, is found in 26 CFR 301.6012-1. And in paragraph C of that regulation, it imposes the duty to file a return only upon non-resident alien individuals. It doesn't even mention those who are either not individuals or who are not non-resident aliens but simply non-residents. So they don't really impose the duty upon those who are non-residents but not individuals, and or those who are non-residents but not non-resident aliens. So there are two types of non-residents, non-resident alien individuals, and they're defined in 26 CFR 1.1441-1C3II, and they are a subset of all alien individuals. Includes foreign nationals but not domestic nationals, and non-residents who are not individuals. This includes people born anywhere in America and domiciled within the jurisdiction, the exclusive jurisdiction of a state of the Union. A non-resident who is not an individual becomes a non-resident alien individual when he or she agrees to occupy a public office in the government. So, let's talk about those non-resident non-individuals. People domiciled in other countries are non-residents but non-individuals. And they are on an equal footing with people born in and domiciled in states of the Union for the purposes of federal income taxes. See IRS Publication 54, confirmation of this fact. And a non-resident who is not an individual is not an alien or an alien individual under the Internal Revenue Code. Non-resident non-individuals have no liability under the Internal Revenue Code. They can earn no gross income because 26 U.S.C. 871 describes taxable income of non-resident alien individuals, but not non-residents who are not individuals. And they cannot have liability to file a tax return because 26 CFR 1.6012-1B only imposes that duty on U.S. persons, statutory U.S. persons, and non-resident alien individuals. Those who are not non-resident non-individuals are nowhere described as having a liability to file a tax return. So let's get into the rules of statutory construction, because this is how most of the confusion and theft is instituted by words of art and deception they perpetuate. It is a maximum of statutory construction and interpretation that things such as non-residents who are not individuals and who aren't mentioned in the code aren't subject and are purposefully excluded and do not have a liability. That's important. And here are those rules of statutory construction from Black's Law Dictionary, 6th edition, page 581. Expressio unius ex exclusio alterius, a maxim of statutory interpretation meaning that the expression of one thing is the exclusion of another. Bergen versus Forbes. Mention of one thing implies exclusion of another. When certain persons or things are specified in a law or contract or will, an intention to exclude all others from its operation may be inferred. Under this maxim, if statute specifies one exception to a general rule or assumes to specify the effects of a certain provision, other exceptions or effects are excluded. And the Supreme Court also demonstrated this in Stenberg versus Carhart in 2000. When a statute includes an explicit definition, we must follow that definition, even if it varies from the term's ordinary or common meaning. Meese versus Keene. It is axiomatic that statutory definition of the term excludes unstated meanings of the term. And Collodi versus Franklin. As a rule, a definition which declares what a term means excludes any meaning that is not stated. Western Union Telegraph Company versus Lenroot. Fox versus Standard Oil. See also Volume 2A of N. Springer's Sutherland on Statutes and Construction. That is to say, the statute read as a whole leads the reader to a definition. That definition does not include the Attorney General's restriction, the child up to the head. Its words, substantial portion, indicate contrary. So what about non-resident alien individuals? Those are the ones who have a liability to file a tax return. The non-individuals, non-resident non-individuals don't. And once again, we want to emphasize, you cannot have any status under the laws of Congress unless you're domiciled on their territory. Because civil status originates, the law of status originates from your domicile. So if you don't have a domicile on federal territory, then you're not an individual, you're not a person, you're not a non-resident alien, you're not a non-resident alien individual, or anything else. And the only way you could acquire any of those statuses is to consent to them, because otherwise you couldn't have them. And that consent would be what the courts would call purposeful availment, and it would result in a waiver of sovereign immunity. So if you didn't consent to the status, then they're exercising eminent domain if they enforce the status and the obligations of the status against you. So in this case, a non-resident alien individuals who are not engaged in a trade or business in the United States, meaning government, and who have no earnings from the District of Columbia do not have taxable source of income and are therefore not taxpayers, pursuant to 26 U.S.C. 871. And the proof is found in 26 CFR 1.872-2F, which says that non-resident aliens with no earnings connected to a trade or business and all whose earnings originate outside the District of Columbia earn no gross income and are not subject to tax. And by District of Columbia, we really mean United States, but we know that the statutory definition of that is possibly federal territory. So we could mean federal territory instead. 26 U.S.C. 861A3CI says that income of non-resident aliens not engaged in the trade or business in the United States is not includable in gross income. And 26 U.S.C. 871A imposes a 30% tax on all taxable income of non-resident aliens not connected to a trade or business, but also originating from, quote, sources within the United States. And taxable sources of income for non-resident aliens are found in 26 CFR 1.861-8F1IV and applies only to income effectively connected to a trade or business. All non-resident alien individuals are also alien individuals, but not vice versa. A non-resident alien may elect to be treated as an alien under 26 U.S.C. 1613G and 26 U.S.C. 7701 B4B. And that provision in Section 6013 requires that the non-resident alien individual must be married to a U.S. citizen. And by making the election to be treated as an individual, essentially they're electing to be treated as a U.S. citizen and having the same status as their spouse. And if they're not married to a U.S. citizen spouse, a statutory U.S. citizen spouse, they are not allowed to make that election, ever, which means they can never become an alien individual under the Internal Revenue Code. Non-resident alien individuals earn gross income or taxable income only on the following: earnings connected with a public office with the United States government, which is what a trade or business is defined as, is in 26 U.S.C. 7701A26. See also 26 U.S.C. 871B, and earnings not connected with a trade or business from within the District of Columbia under 26 U.S.C. 871A. And by District of Columbia, we really mean the United States here. They're synonymous in our discussion here. And non-resident aliens file Form 1040-R, not the Form 1040. It says so right on the form. And the use of IRS Form W8BEN to stop withholding. See about IRS Form W8BEN, Form 04.202 on our website. And non-resident aliens file tax returns at the Philadelphia Operational Branch and not any district office or service center. And they do not reside in any Internal Revenue District or United States Judicial District and are not subject to the jurisdiction of the federal courts. Non-resident alien individuals are not engaged in a trade or business, are described in 26 CFR 1.871-1B1I, and they do not earn gross income on earnings from outside the United States. And here's the proof. Income which is from sources without, that is outside the United States, that is the District of Columbia, or any federal territory, one might add, as determined under provisions of Sections 861 and 863 and regulations thereunder, is not included in gross income of the non-resident alien individual unless such income is effectively connected for the taxable year with the conduct of a trade or business in the United States by that individual. And non-resident alien individuals not engaged in a trade or business are not required to do backup withholding or 1099 withholding. And they don't earn reportable wages on IRS Form W-2. See 26 U.S.C. 3401A 6, except that such terms shall not include remuneration for such services performed by a non-resident alien individual. So you don't earn wages if you're a non-resident alien. And why is that? Because a resident or a citizen really is, in the Internal Revenue Code, we see simply as an office in the government. And so it really doesn't matter what you call that office, but if you're not engaged in the office, then you can't earn wages, because wages are earnings from an office in the government. And that's consistent with the W-4 form, which identifies itself in the upper left corner as employee withholding allowance certificate. You have to be an employee, an officer, as we showed in 5 U.S.C. 2105A, in order to be an employee and therefore an officer. And if you're not an officer, then you're non-resident. And so you can't earn wages at that point. And they do not need to use identifying numbers on their financial accounts. And that's shown in 1.1441-6 of Title 26 regulations. You can read that for yourself. A non-resident alien individual may elect or consent to be treated as a resident under the following provisions of law. 26 U.S.C. 1613 G and H, which is a non-resident alien individual married to a U.S. citizen spouse, or 26 U.S.C. 7701 B4B, or 26 CFR 1.871-1A, or the Foreign Sovereign Immunities Act, 28 U.S.C. 1605A2, which says that those who conduct commerce within the legislative jurisdiction of the United States, e.g. the federal zone, surrender their sovereign immunity. And this is what they call the Foreign Sovereign Immunities Act. And the exceptions are: a foreign state shall not be immune from the jurisdiction of courts of the United States or of the states in any case in which the action is based upon commercial activity carried on in the United States by the foreign state or upon an act performed in the United States in connection with a commercial activity. And this applies to human beings because they are domiciled in a state of the Union, which is a legislatively foreign state, and therefore they are agents and officers of that state if they are serving in a public office of that state. And they are if they are also filing state taxes. If you would like to learn more about tax obligations of a non-resident alien, see the non-resident alien position, Form 05.020. So, why don't more people file as non-residents? Deceptive and incomplete trade publications on the subject of payroll withholding for non-residents not engaged in a trade or business. That's the most important source. See the payroll source, American Payroll Association, Principles of Payroll Administration, 2004 edition, Payroll Answer Book, 3rd edition, just as an example. And all of those documents consistently misrepresent the withholding requirements toward non-resident aliens. And they really don't understand what a non-resident alien is. And so they'll try to shoehorn you into what they do understand, which is being a U.S. citizen or a U.S. resident, which we know is just a public officer. So indirectly, most payroll departments in most companies will effectively act as employment recruiters for uncle and make you into a public officer, whether you want to be or not. And they'll do it for the sake of convenience. And if you don't want to work for uncle and you don't want to be a public officer, or you don't want the benefits or obligations of the office, you've really got to educate these people. And they're going to play dumb up to the very last minute because they don't want to know the truth, and they've got a cognitive block against learning the truth. And the minute they learn the truth is the minute they have to admit they've been doing it wrong their whole damn life, and they don't ever want to do that. So it's an ego issue for them as well. So you have to take time and educate these people, and maybe even draw in the corporate counsel to make sure he knows too. Another reason why they don't file as non-residents is that payroll clerks who are too busy or lazy to read the law for themselves, or fear of illegal IRS retaliation and enforcement, or cognitive dissonance with the word non-resident alien being used to describe the average American, or tax preparers and tax professionals being brainwashed by the IRS to steer people away from this approach by propaganda that the courts refuse to make them accountable for. And the tax rate on non-resident alien individuals is a flat 30% instead of the graduated rate found on the Form 1040. This leads people to avoid this status because the tax rate appears higher, but in fact is lower, 0 for the average American. See Section 871. And when people first start off in the tax system by filing their first tax form, they choose the 1040 instead of the 1040-R because it gives them a lower rate initially, and they continue with this bad and wrong habit for the rest of their lives. And the 1040-R forms are made deliberately more difficult to obtain in most post offices and other sources, and the 1040-R is more complicated to fill out, so people naturally avoid it. Aliens versus non-resident aliens. Aliens and non-resident aliens are not equivalent. Aliens and resident aliens are defined in 26 U.S.C. B1A, and non-resident aliens are defined in 26 U.S.C. 7701 B1B, which we showed earlier. Individuals. Individuals are the people required to file IRS Form 1040. All individuals are aliens pursuant to 26 CFR 1.1441-1C3. And individuals exclude people born in America and domiciled in states of the Union, called nationals or non-citizen nationals, as defined in 8 U.S.C. 1101A21. And alien individuals are defined in 26 CFR 1.1441-1C3I, and aliens occupying a public office in the government. That's what they are, because we said individuals are public offices. So if you're an alien individual, then you're an alien who's in a public office. Like a statutory alien, not a constitutional alien. And non-resident alien individuals are defined in 26 CFR 1.1441-1C3II, and they are a subset of alien individuals. Non-individuals. Alien non-individuals include foreign nationals and exclude people born anywhere in America and domiciled in states of the Union. And non-resident alien non-individuals are not a subset of all aliens and include people born anywhere in America and domiciled in states of the Union and foreign nationals not occupying public offices in the government. The IRS deliberately tries to confuse non-resident aliens and aliens in Publication 519 by referring to all non-resident aliens as aliens, but they are not equivalent unless the party is also an individual. So what is a tax, quote unquote? Taxes are defined in Black's Law Dictionary, 6th edition, page 1457. Tax, a charge by the government on the income of an individual, corporation, or trust, as well as the value of an estate or gift. The objective in assessing the tax is to generate revenue to be used for the needs of the public. And a pecuniary, that is relating to money, burden laid upon individuals or property to support the government and is a payment exacted by legislative authority. Essential characteristics of a tax are that it is not a voluntary payment or donation, but an enforced contribution exacted pursuant to legislative authority. Okay, so the important thing here is that it may be voluntary for some, but not for all. An example is, if you're not a public officer and therefore not an individual, then it would be voluntary for you because you'd first have to volunteer to become a public officer. On the other hand, if you were already a public officer in the government, then it would not be voluntary for you. So the duty is associated with the status of individual and public officer and trade or business. It's not associated with generally with everyone. In that sense, it's a class legislation. It's private law that only applies to certain people in certain conditions. It doesn't apply equally to everyone. And they don't point that out here, unfortunately. But the implication here is that the individual they're talking about and the property they're talking about are public offices and federal property, public property. Because any property you use in connection with the office is government property. Because the office cannot administer private property. You cannot exercise any authority over private property because, as we said, the ability to regulate private rights and private property is repugnant by to the Constitution as held by the Supreme Court. So it has to be public before they can tax it. And you have to volunteer for the office before it is public. So that's how it works. And if you're not a public officer, then it's not public and therefore it's not taxable. Only legitimate purpose of taxes is to support the government and not the people or constituents. And here's what the Supreme Court said on this in 1936, U.S. versus Butler, right around the time the Social Security was enacted. They said, quote, a tax, in the general understanding of the term and as used in the Constitution, signifies an exaction for the support of the government. The word has never thought to connote the expropriation of money from one group for the benefit of another. So in other words, the government cannot use their taxing powers to redistribute wealth from one class of people to another class of people. You know, the haves, they cannot redistribute wealth using their taxing power from the haves to the have-nots, for instance. And if they do, they're abusing their taxing power, they're engaging in unconstitutional activity, and they're also engaging in treason because they're destroying the separation between public and private and between the states and the national government. And they also said, Supreme Court said in 1874 on this same subject, to lay with one hand the power of the government on the property of the citizen and with the other to bestow it upon favored individuals to aid private enterprises and build up private fortunes is nonetheless a robbery because it is done under the forms of law and is called taxation. This is not legislation. In other words, it's not law. That's what they just said. It is a decree under legislative forms. And by the way, that is the very reason why the Internal Revenue Code is not positive law, and therefore is prima facie and a presumption, and therefore is non-binding on anyone. It has to be positive law to be legal evidence of an obligation. And since it's not positive law, essentially it is, just as they describe here, not legislation and is a decree under legislative forms. In other words, it looks like law, but it's really public policy disguised to look like law. And that policy only regulates people in the executive branch and no one else. And those people are public officers, all of them. And it says, nor is this taxation. A tax, says Webster Dictionary, is a rate or sum of money assessed on the person or property of a citizen by government for the use of the nation or state. Now notice, for instance, that the term citizen does not include alien. So they can't assess the tax on an alien. That's why a non-resident alien is if he's not an individual, is not a taxpayer, because a citizen is, in the case of the Internal Revenue Code, is also a public office. So it says taxes are burdens or charges imposed by the legislature upon persons or property to raise money for public purposes. So they cannot, once again, use their taxing power to redistribute wealth. They cannot redistribute money from one class of people, the haves, to the other class, the have-nots. They cannot bribe voters with benefits to vote in a certain way to perpetuate those benefits, or to elect politicians who will perpetuate those benefits. That's bribery of voters has always been a crime. Bribery of jurists has always been a crime. You can't go in front of a jury and tell them that Mr. So-and-so, who's being convicted for failure to file a tax return or failure to pay under the Internal Revenue Code, you can't tell that jury full of taxpayers and tax consumers that their tax bill is going to go up if they don't convict this guy, because that would be a criminal and financial conflict of interest. So you've got to keep the public and the private separate, and the only way they can be separate is for the taxpayers to be public and to not distribute public monies to private citizens. So very tricky. So what did this same Supreme Court say about people who try to abuse the taxing power of the government to redistribute wealth? The Supreme Court said that when the government abuses its taxing power to redistribute wealth, any statute which implements it is not law and constitutes, quote, political heresy, unquote, that is completely contradictory to the concept of republican government that is the foundation of our system of government. Hello? And here's what they said in the sinking fund cases, 99 U.S. 700, 1878, quote, in Calder versus Bull, which was here in 1798, Mr. Justice Chase said that there were acts which the federal and state legislatures could not do without exceeding their authority. And among them, he mentioned a law which punishes a citizen for an innocent act, a law that destroyed or impaired the lawful private, that is labor contracts and or labor compensation, e.g. earnings from employment through W-4, of citizens, a law that made a man a judge in his own case, and a law that took the property from A, that is the worker, and gave it to B, the government, or another citizen, such as through social welfare programs. It is against all reason and justice, he added, for people to entrust a legislature with such powers, and therefore it cannot be presumed that they have done it. That is, passed a law in this case. And notice they use the word presumed. Well, the whole Internal Revenue Code is just a big presumption because it's not positive law. So that's exactly what that code does, is it presumes that it has the authority to do that, which they said here wasn't allowed to be done. Hello? Moving on. They may command what is right and prohibit what is wrong, but they cannot change innocence into guilt or punish innocence as a crime or violate the right of an antecedent lawful private contract, for instance, by compelling a W-4 withholding, for instance, or the right of private property to maintain that a federal or state legislature possesses such powers of theft, if they had not been expressly restrained, would, in my opinion, be political heresy, altogether inadmissible in all free republican governments. So they're not allowed to do it. And that's why the Internal Revenue Code is not positive law. That's why it's a big presumption. The whole title is a big presumption. And that presumption is exactly what they described here as presumed. Okay, they're presuming that they can do these things, which they earlier in the Supreme Court said they weren't allowed to do. And so they're not allowed to do it. And we know why they're doing it. We know it's because of the fiat currency system and the Federal Reserve and all of the imbalances that counterfeiting franchise institutes in an otherwise righteous populace. You know, the minute you give any government the right to print unlimited supplies of money, you've got to provide a way to retire those monies from circulation. And the only way you can do it is to institute a national income tax, illegally, we might add, and in violation of exactly what the Supreme Court said is going on here, because they're redistributing wealth with it now. And they're using it to buy votes and so on. So where do your taxes go? Here is what a legal education book from Westlaw says on that subject. Federal Income Taxation on Individuals, West Group, 1999, ISBN 0-314-23868-9, page 2. And look at this chart. It shows the income on the top and the outlays on the bottom. Okay, now all this stuff in this big pie piece here is Social Security, 38%. Now it's up to about, it's well beyond 50% now. So it's grown like a tumor and a cancer. Okay, but all of those social welfare or entitlements are all paid to, and in social programs as well, are all paid for the benefit of private parties. And so automatically they're not an allowed use of federal taxing power, number one. And number two, they therefore represent a redistribution of wealth. And this particular book on page 2 actually admits that that's what it's being used for, even though the Supreme Court just said in the previous page that they're not allowed to do it. Look what they said about how it's spent. It says the income tax serves several functions in addition to financing federal government expenditures. So in other words, everything other than federal government expenditures would be redistribution of wealth, is what they're admitting here. And it says it also allocates resources between who? Between the haves and the have-nots, between the public and the private, and so on. It subsidizes some persons or activities, encourages or discourages certain kinds of economic and social behavior. Taxes aren't supposed to be used for that. That's bullshit. And then it says it redistributes wealth, which is exactly what the Supreme Court said they couldn't do in Loan Association versus Topeka, and so on, and Bailey. It says it stimulates or stabilizes economic growth, helps maintain our federalism, and helps some specific social problems such as pollution and urban blah, blah, blah. So what they're using, their taxing powers illegally. They're using it to fund things that are not government expenditures, which are, redistribution of wealth, and that's clearly unconstitutional. And as the Supreme Court said in Loan Association versus Topeka, it's theft in the name of taxation, and they said it wasn't legislation and that it wasn't law. So why are we following that which isn't law? And if it isn't law, what is it? I'll tell you what it is. It's public policy disguised to look like law that only pertains to people who vote themselves into office by filling out tax forms. And that voting yourself into office is also a crime. So in effect, it's deriving revenues from criminal activity, and all the paperwork that's generated as evidence of that activity is fruit of a poisonous tree that's not admissible in any court. Moving on. You don't pay tax to the IRS. That's obvious because, we just learned that a tax is only used to support the government. It's not used for wealth redistribution. It's not used to buy votes. It's not used to bribe juries to vote in a certain way. And yet, so it can't be a tax. And just as we showed in that chart, it's not a tax. Social Security, Medicare, welfare, FICA are not taxes. They are government insurance programs, and all insurance programs are voluntary. And when taxes are used for bribery and wealth redistribution instead of supporting the government only, as the law book on the previous page says, then all governments, judiciaries, and tax collection systems invariably become corrupt, and governments invariably grow out of control because of thirst for money and power, and the liberties of the people are eliminated one by one as taxes are increased, and the tax code becomes a means of political control and tyranny. So what laws are violated when taxes are used for wealth redistribution? Here are a few of them. 18 U.S.C. 2381, treason. 18 U.S.C. 208, conflict of interest. 18 U.S.C. 597, expenditures to influence voting. Because if you bribe voters with government benefits or the protection or expansion of their benefits, then you're bribing a voter. And politicians do that all the time. 18 U.S.C. 2111, robbery. They're stealing your money. 18 U.S.C. 871, extortion. They're extorting it because they're telling you you have to withhold, but you don't. And they're lying to the withholding agents. And they're doing so with impunity because they tell you that you can't trust anything they say, and yet they turn around and say you have to do it. And then the courts refuse to prosecute them for saying the wrong thing, and they refuse to prosecute the withholding agents for also doing the wrong thing under the direction of the false instructions from the IRS. So they all belong in jail, every one of them. Every withholding agent just about belongs in jail if they know this information. 18 U.S.C. 876, mailing threatening communications. All the collection notices are mailing of threatening communications to their not proper party. And all those communications are addressed to Dear Taxpayer, Well, if you're not an office in the government, then it's not directed at you. And indirectly, in effect, they're mailing a threatening communication to a non-party. If you're not a public officer, then you're not a taxpayer. And if you're not a taxpayer, they mailed it to the wrong person. And they're engaging in identity theft. And they're threatening you to accept the duties of an office that you're not in. And so they're essentially blackmailing you, 18 U.S.C. 873, to perform the functions of a public office and to satisfy the obligations of the office without your consent and without even letting you know that you're in the office. And if you prove to them that the law says you're in the office, they would be very reluctant to admit that fact. 18 U.S.C. 1581, peonage in slavery. It's slavery to force you to pay withholdings on your labor. And notice I didn't say withholdings on your wages, because wages are the earnings of a public office. If you're not a public officer, you don't earn wages. If you don't earn wages, you're not subject to withholding. Now, are you? Duh. It's also peonage in slavery under 42 U.S.C. 1994, and it's a violation of the 13th Amendment. For further information on why taxes for wealth redistribution violate the Constitution, read the article below, which is How Scoundrels Corrupted Our Republican Form of Government. So what exactly do you pay to the IRS then? Have you ever wondered that? It is fraud to call what we pay to the IRS a tax, unless we really do work for the government as public employees or public officers. And what private parties who are not public officials pay to the IRS is instead a donation or insurance premium disguised as a tax to make it look mandatory. And here are some of the terms that describe that in Black's Law Dictionary, 6th edition, page 487. Donatio, a gift, a transfer of the title of property to one who receives it without paying for it. The act by which the owner of a thing voluntarily transfers the title and possession of the same from himself to another without any consideration. That's what it is. It's a donation. And you can prove that by looking in Title 31, Section 321D. It's identified as gifts. And as a matter of fact, all your withholdings that are sent into the IRS are identified as Tax Class 5, which is gifts to the government. So you're just paying donations, and it's the same kind of donation you'd pay to a church. A tithe to a church or an offering to a church is a gift, and that's exactly what you're giving to these people because they're engaging in a religion too. Another term they use is voluntary, unconstrained by interference, unimpelled by another's influence, spontaneous acting of oneself. Okay, so you cannot be subject to threats and duress and penalties of any kind on the one hand, and then on the other hand to call those contributions voluntary. Now, can you? So they're engaging in what Orwell calls doublethink. They're calling it voluntary, and they're saying it's voluntary, but they won't protect your right to not volunteer, and they'll penalize you for not volunteering, which is fraud. The IRS doesn't maintain tax records about you. They maintain records of your donations, in the case of withholdings, at least, because of the tax class that they're under, Tax Class 5. And the federal income tax system under Subtitle A of the Internal Revenue Code is a donation program for the municipal government of the District of Columbia, which we call the District of Criminals. And we didn't originate that term. Mark Twain did. He was the first one to call the District of Columbia the District of Criminals, and he was absolutely right. So who are taxpayers? A taxpayer is defined in 26 U.S.C. 7701A14 as the term taxpayer means any person subject to the Internal Revenue tax. Okay, so how would they be subject? They would be subject by occupying a public office, and only by occupying a public office. Because if they didn't occupy a public office, they would not be subject to federal jurisdiction and therefore liable for enforcement. The Federal Rule 17 of Civil Procedure 17b says that the law of the party's domicile, the capacity to sue or be sued shall be determined by the law of the party's domicile. People who are in a state of the union are domiciled in a state, and therefore they're not subject to federal law. So the only way they could become subject is to represent an entity that is subject as a public officer. And that entity is the United States as a federal corporation, and that corporation is domiciled in the District of Criminals. The definition of subject to: liable, subordinate, subservient, inferior, obedient to, governed or affected by, provided, answerable for, and on and on. Black's Law Dictionary, 6th edition, page 1425. So if you aren't engaged in a trade or business, then you aren't a taxpayer. under IRC Subtitle A, and you aren't an individual under IRC Subtitle A. Federal courts aren't allowed to determine if you are a taxpayer. See 28 U.S.C. 2201A and the case below. CIR versus trustees of loan, so on. And by statutory definition, taxpayer includes any person, trust, or estate subject to a tax imposed by the Revenue Act. Since the statutory definition of taxpayer is exclusive, the federal courts do not have the power to create non-statutory taxpayers for the purpose of applying the provisions of the Revenue Acts. In other words, they cannot create new public offices who are taxpayers. Why? Because the Internal Revenue Code does not authorize the creation of any new public offices, including any new taxpayers. And you cannot unilaterally elect yourself into a public office by filling out any government form. You have to take an oath, you have to be lawfully elected or appointed, and so on. And you have to be an employee under Title V, Section 2105A, in order to be a public officer, and therefore a taxpayer. Subtitle A of the Internal Revenue Code only makes withholding agents of non-resident aliens liable in 26 U.S.C. 1461. No one else is made liable unless they volunteer. 26 CFR 1.1-1b is an exception to this, but it is an illegal regulation because broader than the statute it implements. And this is proven in the Great IRS Hoax, Form 11.302, Section 5.6.1. So how does one volunteer? And the answer is by filling out either a 1040 tax return or a W-4 and sending it in. And that tax return and that W-4 are going to be false and fraudulent and should be prosecuted as both if you send it in and you're not already lawfully occupying a public office in the government. So the nature of the Internal Revenue Code, Subtitle A. Subtitle A of the Internal Revenue Code describes an indirect excise tax, which is a tax only upon artificial entities and businesses and not biological people. All excise taxes are imposed on licensed or privileged activities, and the privilege is a public office, as we just said. And within states of the Union, federal government only has jurisdiction to tax imports under the Constitution, Article 1, Section 8, Clause 3. This is the only privileged or taxable activity applicable to states of the Union, and it is only taxable to federally registered corporations. And within the federal zone, Article 1, Section 8, Clauses 1 and 17 of the Constitution gives Congress unrestricted jurisdiction to tax anything it likes, not just importation by corporations. This is called municipal taxation. The District of Columbia is a municipal corporation, and IRC Subtitle A applies primarily to those domiciled within the limits of that municipality. That is why it is called the Internal Revenue Service, because it is internal to the District of Columbia and or the United States government itself. And here is some supporting information. The Geographical Definition of the United States. In Section 7701A9 and A10 of the Code, the term United States, when used in a geographical sense, includes only the states and the District of Columbia, and the term state. The term state shall be construed to include the District of Columbia where such construction is necessary to carry out the provisions of this title. So there is no definition of state included within the geographical definitions of the Internal Revenue Code. Constitutional states, we mean. Of the interpretation of the meaning of the above definitions, the U.S. Supreme Court has held in Stenver versus Carhart that you cannot add to those definitions. When a statute includes an explicit definition, we must follow that definition, even if it varies from the term's ordinary meaning. Now, we might add that it's perfectly acceptable to construe that a public office could be exercised in a constitutional state, and that office would be subject to federal taxation upon only the office and the officer. Okay, and there are many public offices that are exercised in constitutional states. An example would be military officers or federal judges, okay, or congressmen when they're on leave at home. Okay, all those people are lawfully serving in a public office in the District of Columbia, and yet they are treated as though they're in the District of Columbia under Federal Rule of Civil Procedure 17b, regardless of where they physically are. But under 4 U.S.C. Section 72, the Secretary has to expressly authorize the exercise of that office in a place outside the District of Columbia before it is subject to federal jurisdiction. And if it isn't, they can't collect the tax. They cannot tax where they have no jurisdiction now, can they? And Supreme Court also said it is axiomatic that the statutory definition of the term excludes unstated meanings of that term. Congress's use of the term propaganda in this statute as indeed in other legislation has no pejorative connotation. As judges, it is our duty to construe legislation as it is written, and not as it might be read by a layman, or as it might be understood by someone who has not even read it. If the IRS wants to argue with you about the above definition, then hand them the following and ask them to rebut the questions at the end. Meaning of the words includes and including. Form 05.014 on the forms page. And the Internal Revenue Code Subtitle A applies mainly to U.S. persons defined in 26 U.S.C. 7701A30, all of whom have a domicile in the District of Columbia or federal territory, we might add. And this includes residents who are all aliens of the federal zone, and excludes land within the states of the Union, not under federal jurisdiction, and U.S. citizens working abroad and outside the United States, states of the Union. So, in other words, aliens at home and citizens abroad. And by home, we mean federal territory. And by abroad, we mean outside the country, United States. So those are the only two classes of people that they can reach. Non-resident aliens with taxable income originating in the District of Columbia per 26 U.S.C. 871, or in this case, the United States, because as we said before, District of Columbia and the United States are synonymous here throughout this presentation. If people in states of the Union file under IRC Subtitle A, the proper form to use is the 1040 NR, not the 1040, and to report income from the federal zone that is connected with a trade or business under 871B, which is defined in 7701A26 as the functions of a public office, or not connected under 26 U.S.C. 871A. And those things, the not connected ones in 871A, are sources within the United States, which is defined in 864C3 as connected to a public office. So even that is connected to a public office. So that's why we keep saying all roads lead back to the public office and the taxpayer being a public office. A non-resident alien may elect to file a 1040 but has elected to be treated as a resident under 6013G and 7701B4B. Bad idea. And the IRC describes taxation for two mutually exclusive territorial jurisdictions. The two following slides summarize these jurisdictions. So we have the two jurisdictions, the national government of the District of Columbia and the federal territories, and the federal government of the states of the Union. And the constitutional article authority for the revenue collection is Article 1, Section 8, Clause 1 and 17 for the federal territory, and Article 1, Section 8, Clause 3 for states of the Union. And that sort of taxation is on imports only. The type of jurisdiction exercised is plenary and exclusive in the case of the federal zone, and subject matter in the case of the states. And the nature of the tax is an indirect excise tax upon privileges of public office in the national government, whereas it's an indirect tax on imports only for the states, and excludes exports from states and excludes commerce exclusively within states. And the taxable objects are internal to the federal zone or internal to the federal government for the national government, and external to the states of the Union, that is imports coming in, for the federal government, and so on. The Revenue Collection Agency, Internal Revenue Service for the national government, and U.S. Customs for the federal government. And the authority for collection within the Internal Revenue Code is subtitles A, B, C, and E for the national government, and subtitle D for the federal government. And the revenue collection applies to public officers engaged in a trade or business franchise in the national government, or federal corporations involved in foreign commerce in the case of the federal government. And moving on, taxable activities, trade or business, or the transfer of property from people who died in the federal zone under subtitle B for the national government, and foreign commerce under the federal government. Revenues paid for socialism and communism in the national government, or protection of the states of the Union, including military courts and jails in the case of the federal government. And the definition of the term United States is found in 26 U.S.C. 7701A9 and A10, as we just showed, and 26 U.S.C. 3121E in the case of the national government, whereas in the federal government, it's the states of the Union. And the example taxes, W-4 withholding on federal employees for the national government, estate taxes, Social Security, Medicare, alcohol, and blah, blah, blah. And taxes on imported fuels would be for the federal government. And the applicable tax forms are the resident tax forms on the left, and customs tax forms on the right. Taxable income. What is it? It's described in Section 863A, And here's the definition. Items of gross income, expenses, losses, deductions other than those specified in sections 861A, 862A shall be allocated or apportioned to sources within or without the United States under regulations prescribed by the Secretary. Where items of gross income are separately allocated to sources within the United States, there shall be deducted for the purpose of computing the taxable income therefrom the expenses, losses, and other deductions properly apportioned or allocated thereto, and a rateable part of other expenses. 26 U.S.C. 861 describes taxable sources within the federal United States, meaning the federal zone, and 862 describes taxable sources outside the federal United States, meaning federal zone. The only taxable sources from within the United States are identified in 26 CFR 1.861-8F1, and 26 CFR 1.862-1B says to use the form of the same 26 U.S. CFR 1.861-8F to compute income from sources without the United States also. Taxable sources of income under 26 CFR 1.861-8F1 include DISC and FSE income, which mean domestic, international sales corporation, and foreign sales corporation. In other words, foreign commerce. Income connected with the trade or business, foreign-based company income, and other operative sections identified in 1.861-8F1BI. Okay. Important thing to remember is that there are only two types of income that are taxable or gross income. Income from foreign commerce under Article 1, Section 8, Clauses 1 and 3, and income effectively connected with a trade or business in the United States, which means income derived from public office. See 26 U.S.C. 7701A26 for the definition of trade or business, and 26 CFR 1.861-8F1IB for the only taxable sources of income to humans. The two types of taxable income are clearly shown in IRS publications. The IRS 1040 booklet for 2001 on page 20 under the income only lists foreign source income and wages under IRC Subtitle A, which is income subject to voluntary withholding agreement under 26 CFR 31.3401A-3 and originating from public office in the District of Columbia. Click here to see the above 1040 booklet for yourself. If you write the IRS Disclosure Office and ask them for the right form to use for people who don't work for the government and are private workers with no trade or business earnings, they will tell you, we have no documents responsive to your request. And that should be a clue that you're not a taxpayer. Hello? And Treasury Order 150-01 says in paragraph 3 that U.S. territories and insular possessions, the Commissioner of Internal Revenue shall, to the extent of authority vested in the Commissioner, provide for the administration of the United States Internal Revenue laws in the U.S. territories and insular possessions and other areas of the world. Notice the states of the Union are nowhere mentioned there. So once again, they can only enforce within federal territory. Notice the above Treasury Order does not mention states of the Union, and by the rules of statutory construction, that which is not expressly included is purposefully excluded. So let's look at the federal filing status of people in various conditions. So on the left-hand side, we have the condition, and on the right-hand side, we have the domicile of the party, because domicile is the origin of your tax liability. So we have, and there are three types of domicile you can have. Domiciled within the federal zone, meaning federal territory, and located in the federal zone. You can be domiciled in the federal zone and temporarily located abroad in a foreign country, or you can be domiciled without the federal zone and located without the federal zone in the third column here. So the location of domicile, if you're domiciled in the federal zone in the United States per 7701A9 and A10 and 7701A39 and 74OD, and if you're domiciled within the federal zone but located abroad, it would be 7701A9 and A10 and so on for all of these. The physical location of the person is federal territories, possessions, and the District of Columbia for domiciled within the federal zone, or foreign nations only if domiciled in the federal zone and located temporarily abroad, or foreign nations, states of the Union, and federal possessions in the case of domiciled without and located without. And the tax status of people domiciled in the federal zone is a U.S. person, which includes citizens and residents, statutory citizens and residents. Same thing for those who are still domiciled in the federal zone but abroad. But if they're domiciled outside the federal zone and located outside the federal zone, then they're non-residents or non-resident aliens, depending on which you want. So the tax forms to file for, if you're domiciled in the federal zone, is the 1040, which is the U.S. individual. That's what an individual is a public office domiciled in the federal zone. IRS Form 1040 plus the 2555 when you go abroad and maintain your domicile in the federal zone. And IRS Form 1040-NR if you're an alien individual or a non-resident alien individual. But there is no filing requirement if you're a non-resident, non-individual. So, and that would include people in states of the Union. The status, if a national of the United States, **, meaning a person domiciled on federal territory, is a citizen, 8 U.S.C. 1401, or a citizen abroad, or a non-citizen national. And the status, if they're a foreign or USA national, meaning a person born or naturalized in a foreign country or state of the Union, means they're a resident alien if they're domiciled on federal territory, and a resident alien abroad if they're domiciled on federal territory but abroad under Section 911 of the Internal Revenue Code, or a non-resident alien individual if they're a public officer, or a non-resident alien non-individual if they're not a public officer in the U.S. government. And so some notes on this. United States is defined as the District of Columbia and no part of any state of the Union within 26 U.S.C. 7701 A9 and A10, 7701 A39, and 7408D. The District of Columbia is defined as a federal corporation but not a physical place, a body politic, or a de jure government within the District of Columbia Act. And American citizens who are domiciled outside the federal jurisdiction, either in a state of the Union or a foreign country, are nationals but not citizens under federal law. See why you're a national or a state national and not a U.S. citizen, Form 05.006. And temporary domicile in the middle column on the right must meet the requirements of the presence test documented in IRS publications, and the federal zone equals the District of Columbia and territories of the United States. And all nationals but not citizens above in the right column are also classified as non-resident aliens, 26 U.S.C. 7701B1B, if they are serving as public officers. And the term individual, as used in the IRS Form 1040, means an alien engaged in a trade of business. All taxpayers are aliens engaged in a trade of business. This is confirmed by 26 CFR 1.1441-1C3, 26 CFR 1.1-1A2II, and 5 U.S.C. 552A, paragraph A2. Statutory U.S. citizens, as defined in 8 U.S.C. 1401, are not individuals unless temporarily abroad pursuant to 26 U.S.C. 911 and subject to an income tax treaty with a foreign country. In that capacity, statutory U.S. citizens interface to the IRC as aliens rather than U.S. citizens through the tax treaty. So, for most Americans, the IRS Form 1040 is the wrong form. That form is only for use by citizens and residents of the United States, meaning the District of Columbia or the government or federal territory. See IRS Published Product Catalog, Document 7130. Annual income tax return filed by citizens and residents of the United States. That's what the 1040 is for. There are separate instructions available for this item. The U.S. individual described in the upper left corner of the IRS 1040 is a government employee or instrumentality or office who has a domicile in the District of Columbia and who is a resident but not a citizen. See 5 U.S.C. 552A, paragraph A2, and 26 CFR 1.1441-1C3. The term individual means a citizen of the United States or an alien lawfully admitted for permanent residence. So, and all of those terms are relative to the statutory United States, which means federal territory. Note the above definition is in Title V, which is government organization and employees. All individuals are public officers who work for the government. And public offices, actually, we should say. The term individual is nowhere defined in 26 U.S.C. because the government doesn't want you to know what it means. 26 CFR 1.1441-C3 defines it as an alien or a non-resident alien individual. Nowhere does the definition include citizens. So you cannot be an individual and a citizen at the same time. It's an oxymoron, unless you're abroad under Section 911. And then you're an alien. And that's how you become an individual, because you're an alien through the tax treaty. Those who are not public officers or federal employees cannot truthfully describe themselves as individuals. And the only type of earnings you can put on an IRS Form 1040 are earnings connected with a trade or business. This is proved in 26 U.S.C. 864C3, which defines sources within the United States as connected to a trade or business. And if you are a non-resident alien or a non-resident alien non-individual, then you can't truthfully file the 1040 and must instead file the 1040-NR or 1040-EZ. If you do, you're making an election to be treated as a resident and an alien under 26 U.S.C. 6013G and 26 U.S.C. 7701B4B. It is unlawful for a non-resident alien who is not married to a U.S. person to make such an election. Nowhere in the IRC is such an election authorized, and this applies to most Americans. If they file a 1040 and they're not married, and they're not domiciled on federal territory, and they're therefore not a statutory citizen or a statutory resident, then they're committing a fraud. This is a fraudulent return. And the IRC treats U.S. citizens, that is statutory U.S. citizens under 8 U.S.C. 1401, as aliens coming under a tax treaty with a foreign country when they are abroad. And that's found in 26 CFR 1.1-1A2II, 26 U.S.C. 911, and Cook versus Tate. The Supreme Court authorized the imposition of income taxes on statutory citizens of the United States under 8 U.S.C. 1401, but only when abroad. So watch out. So how does a non-resident become a resident, you might ask? We covered earlier that most people in states of the Union are non-residents relative to federal jurisdiction or national jurisdiction. We also showed that the main taxable activity is a trade or business, which is defined in 26 U.S.C. 7701A26 as the functions of a public office. Those who are engaged in a trade or business are treated as residents of the District of Columbia, which is what the United States is defined as in 26 U.S.C. 7701A9 and A10. Those engaged in a trade or business hold public office, for U.S.C. Section 72 places all public offices exclusively in the District of Columbia, and those engaged in a public office are representing a federal corporation called the United States. This corporation is a statutory U.S. citizen, and therefore they are statutory U.S. citizens while exercising the duties of their public office. This is confirmed by Federal Rule of Civil Procedure 17B. And 26 U.S.C. 7701A39 moves the effective domicile of U.S. persons to the District of Columbia for the purposes of court jurisdiction, and 26 U.S.C. 7408D does the same thing. So those two provisions, 7701A39 and 7408D, govern the choice of law, so to speak, under the franchise. And the franchise is subtitles A and C, the employment franchise, public officer franchise of the United States government. So if you're engaged in that franchise, then you consent implicitly to the choice of law rules that move the activity effectively for all legal purposes to the District of Columbia, whether you physically are domiciled there or not. And so the office, at that point, when you represent the office, you assume the domicile of the office and not your own domicile. And since tax liability is associated with domicile, then the taxpayer is the office. The office is domiciled in the District of Columbia and therefore within the exclusive jurisdiction of Congress and therefore subject to the tax. So in effect, they're engaging in what we call identity theft. They're kidnapping people in states of the Union by fooling them into volunteering for offices. And once they volunteer for the office, illegally we might add, because you can't unilaterally elect yourself into the office, then the choice of law switches to the District of Criminals, and you become subject to the laws of Congress even though you're not physically there, and even though you're not domiciled there, because you are surety for the office as the public officer. So there's two components to the tax. There's the public office and the public officer. The public office is the taxpayer. The public officer is the human filling the office, or the corporation filling the office. And that officer is surety for the office by and only through his consent. So if he never consented to the office and he's being called to perform the duties of the office, then he's being enslaved. And that's a violation of the 13th Amendment. And what they don't want you to know is that you have to volunteer for the office before they can tax you. And so that's a subject that they don't want to talk about, even though it's true. Because they want to confuse the officer with the office. They want to confuse the public with the private. The officer is the private. The office is the public. They want to confuse the office with the officer so they can steal the private. And in that sense, in the process of stealing the private and stealing your private property is what we call anti-government activity. It performs the function opposite to what governments are created to do, which is to protect private property. You don't steal what you're trying to protect, now do you? 26 CFR 301.7701-5, the older version, proves that excise taxable privileged activity of being engaged in a trade or business makes one into a resident, even if they are otherwise non-resident alien. So watch out. And so this proves what we just said about the office being the taxpayer instead of the officer. And this is so damning and so telling that as soon as we discovered it and posted it, they renamed the regulation to a temporary regulation and removed it so people wouldn't know about this. But it's still true. This regulation was not repealed. It was just rewritten. So this is still true, and it's still publicly noticed, and it's still legal evidence for that matter. So here it is, 26 CFR 301.7701-5, domestic, foreign, resident, and non-resident persons. This is one of our favorite quotes. And by the way, everything they're describing in this regulation directly correlates with the definition of person found in 26 U.S.C. 6671B and 26 U.S.C. 7343. So these are the only, quote, persons, unquote, anywhere in the Internal Revenue Code. So this definition of whether you're resident or non-resident is all inclusive and includes all persons. So here's what they say. A domestic corporation is one organized or created in the United States, including only the states, and during the periods when not states, the territories of Alaska and Hawaii, and the District of Columbia. And those states, those capital S states, are federal territories. And the District of Columbia, or under the United States or of any state or territory. A foreign corporation is one which is not domestic. A domestic corporation is resident corporation even though it does no business and owns no property in the United States. A foreign corporation engaged in a trade business within the United States is referred to in the regulations in this chapter as a resident foreign corporation, and a foreign corporation not engaged in a trade or business with the United States as a non-resident foreign corporation. And they do the same thing for partnership here. A partnership engaged in the trade or business with the United States is referred to in the regulations in this chapter as a resident partnership, and a partnership not engaged in a trade or business with the United States as a non-resident partnership. Whether partnership is to be regarded as resident or non-resident is not determined by the nationality or residence of its members, meaning domicile, or by the place in which it was created or organized. So what they just admitted is that the real taxpayer here is the office. And the office is what they call a trade or business. And unless you're engaging in the office, then you're a non-resident. That's what they just said. And that makes a lot of sense because they cannot regulate, they cannot tax private property or private rights. That's what the Supreme Court said. And if they can't regulate or tax private property or private humans, then you have to be engaged in an office. And once you are, that office has an effective domicile in the District of Columbia and is resident in the District of Columbia. Otherwise, it's non-resident in the District of Columbia, right? Because that's where all the offices have to be exercised. And the tax is on the office and not the officer. The officer is simply surety for the office, and he is surety for the office by his consent. If you want to protect your status as a non-resident, non-individual, then you must not make any elections to be treated as a resident under 26 U.S.C. 6013 G and H, or 26 U.S.C. 7701B4B, or 26 CFR 1.871-1A, or the Foreign Sovereign Immunities Act, 28 U.S.C. 1605A2. And you must file the 1040 NR instead of the 1040 if you file returns at all. And you must faithfully and consistently and timely rebut all false information returns, such as IRS Form W-2, 1042-S, 1098, and 1099. If you don't do the above, then you will be presumed to be a resident and maintain a domicile in the District of Columbia. Why? Because if somebody files an information return on you, and 26 U.S.C. 6041A says it can only be filed in connection with a trade or business, then effectively they're electing you into a public office, aren't they? If you don't rebut that election, or you don't rebut the evidence connecting you to an office, then you're presumed to occupy the office and have the duties of the officer. And at that point, you become a resident, don't you? Because we just saw in that previous regulation that we talked about that being a resident means being an officer. Hello? And if you don't do the above, you will also be unwittingly get sucked into becoming a taxpayer who is subject to the Internal Revenue Code. So, in effect, the information returns are being used as federal election devices to unlawfully elect people into public office. And in conjunction with those information returns, withholdings are being illegally done, and those withholdings function as bribes to cause uncle to treat you as if you are a public officer. That too is a crime. That would be a crime under 18 U.S.C. 210 and 211. So how do non-resident alien non-individuals become non-resident aliens and individuals? A non-resident alien individual is a private human. A non-resident non-individual is a private human. And one transitions from public to private, or private to public, by accepting a public office in the U.S. government or representing an entity that is a public office in the U.S. government, such as a federal corporation, see Federal Rules of Civil Procedure 17b, requires that those representing a federal corporation assume the same domicile as the corporation, which is the District of Columbia, or using an individual taxpayer identification number, also called an ITIN, in connection with an otherwise private activity when mandated by 26 CFR 301.6109-1B2. The use of government property such as TINs, SSNs, or ITINs creates a usually false presumption that the party so using is both an individual and is engaged in the trade or business or public office excise taxable franchise, as described in 26 CFR 301.6109-1B2. And we were talking earlier about information returns, and information returns include such things as the W-2, the 1099, the 1098, and so on here. An information return reports the receipt of trade or business earnings. If you don't have trade or business earnings, either directly connected or effectively connected, then you don't earn income. That's the very definition of a foreign estate in 26 U.S.C. 7701A31. If it's not connected to a trade or business and it's earned by a non-resident alien who's not an officer in the government, then it's not taxable and it's not income and it's not gross income. So the purpose of information returns is to report receipt of earnings directly connected to a trade or business. And the requirement for filing information returns originates in 26 U.S.C. 6041. In paragraph A says payments of $600 or more. All persons engaged in a trade or business and making payment in course of such trade or business to another person of rent, salaries, wages, premiums, annuities, blah, 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 shall render a true and accurate return to the Secretary under such regulations in such form and manner and such extent as may be prescribed by the Secretary, setting forth the amount of such gains, profits, and income. So the key thing here is that only persons have this obligation, and we know that all persons and individuals are officers in the government because they can't regulate private conduct, and it's slavery to impose duties on private parties under the 13th Amendment. And it says all persons engaged in a trade or business. So you have to be in a public office. Matter of fact, the office is the taxpayer, and the office is how you become a person. And it says making payments in the course of such trade or business or public office to another person. So the other person has to be a public officer as well. So if only one end of the transaction is a public office, that is the payer, and the recipient is not, then the information return does not need to be filed. Only if both parties are public offices should the information return, the W-2, the 1098, the 1099, the 1042S, only then should the information return be filed. Those who are not engaged in a public office cannot lawfully have any information returns filed against them, which is most Americans. And if someone fills out a false information return against a person not engaged in a public office or a trade or business, the law provides civil standing to sue them for damages under 26 U.S.C. 7434, and a criminal remedy for impersonating a public officer, 18 U.S.C. 912, and a criminal remedy for filing false returns, 26 U.S.C. 7207. False information returns filed by financial institutions and employers may be corrected, and IRS publishes forms for doing this. For details on tax withholding and reporting, see the following free resources. Income Tax Withholding and Reporting Course, Form 12.004. We cover how reporting and withholding works in detail. Federal and state withholding options for private employers, Form 04.101, which is an instruction manual on how non-resident, non-individuals, and private human beings can handle their withholding and reporting. Federal tax withholding, Form 04.102, which is an abbreviated version of the above that you can hand to employers and business associates to educate them about the laws on withholding, also available on our forms page. Tax withholding and reporting, what the law says, Form 04.103, which is a summary sheet of all laws on withholding and reporting. Demand for verified evidence of trade or business activity, information return, Form 04.007. which is a form you can hand employers and businesses associates, which illustrates the proper use of information returns, and additional forms on the SEDM forms page in sections 4 and 5. So how does all this stuff work? How does the withholding and the reporting interact, and the payment? If information returns create a prima facie presumption that you are a taxpayer with gross income, meaning trade or business income, who is liable under the IRC. IRS Form 1042-S, in fact, labels all earnings it records as gross income rather than trade or business income. And we know that's false. They're not allowed to do that because 26 U.S.C. 6041A says it has to be connected to a trade or business. It does not say that it has to be connected to gross income. So they're bypassing. The 1042-S is used in the case of non-resident aliens. And what they're effectively doing is they're violating 26 U.S.C. 6041A by filing information returns in connection with that which is not trade or business earnings. And they're going straight to calling it gross income instead of trade or business earnings. And they can't do that. And the statutes do not authorize it. There are only 3 ways to discharge a prima facie liability. Filing a tax return and balancing accounts is what removes that presumption of liability and restores you to no presumption of liability. And filing corrected information returns can also zero out the presumption of liability, and allowing IRS to enforce payment through involuntary collections if you don't correct the information returns and you don't file the tax return. On the next page, we show how this process loop works. So you start out as not liable in the green dot, and you become liable and have a tax debt on the right, and you can only transition from not liable to liable through these processes as indicated. So box 1, you file, basically on box 1, somebody files an information return against the person. So you become liable until you file a return to zero out the liability here. File corrected. So you can zero out the liability and become non-liable again by either filing a corrected information return, item 2, or filing a tax return, item 3, and settling accounts. Or you can, or the IRS can illegally file a false substitute for return, SFR, and then they can do illegal collection enforcement. And once they get the money, they can make you not liable again. But this whole process is a constitutional tort here. They're not allowed to do this outside of federal territory and outside the government, we might add. And on this page, we give you more details. If you'd like to know more about each specific numbered circle on the previous page, for item 2 in the diagram, you'd see Federal Response Letter page, section 4.2, available on our website. And for item 3 on the previous page, example tax statement, which emphasizes non-taxpayer status. Item 4, illegal collection enforcement. Why penalties are illegal for anything but federal employees, contractors, and agents, Form 05.010 on our forms page. And item 5, illegal substitute for returns. Sites by topic, substitute for returns, and why the government can't lawfully assess human beings with an income tax liability without their consent, Form 05.011. So let's talk about how to correct false information returns. Because if you allow them to be filed and you don't dispute them, they will be presumed to be correct. And because they are presumed to be correct, you are presumed to be a taxpayer with a liability because you had taxable, quote, income, unquote, which, as we said, is earnings connected to a public office in the government, either directly through 871B or indirectly through 871A. So financial institutions and private employers frequently file false information returns against others. We have instructions on how to correct erroneous information returns in the case of people who are not engaged in a trade or business or a public office. These are available below. Correcting erroneous information returns, Form 04.001, which condenses the following 4 documents into one with additional information. Correcting erroneous IRS Form 1042s, Form 04.003. Correcting erroneous IRS Form 1098s, Form 04.004. Correcting erroneous IRS Form 1099s, Form 04.005, and correcting erroneous IRS Form W-2s, Form 04.006. If you want to eliminate false W-2 reporting and remove false information return reporting against you in your private employment, the following free resources can be very helpful. Federal and state tax withholding options for private employers, Form 04.101, describes the laws on withholding, and demand for verified evidence of trade or business activity information return, Form 04.007, educates private employers about information reporting and requires them to obey the tax laws. And they're not really even laws. As we said, they're tax codes because they're not positive law. So they can only have the force of law for people inside the government. So we want to emphasize that you should never commit fraud on government forms. Never, ever commit perjury or lie on a government form. And committing perjury on government forms is a serious offense. 26 U.S.C. 7206 makes a fraud on a government form punishable with up to 3 years in jail and up to a $100,000 fine. And 18 U.S.C. 1621 makes perjury punishable by up to 5 years in jail and a fine. The purpose of showing you what the law says is to prevent, not encourage, fraud on government forms. So keep that in mind as you're going out and trying to correct false information returns. What about lawful enforcement activity? Lawful enforcement activity by the IRS requires implementing regulations for the general public. See 44 U.S.C. 1505A, as we talked about earlier, 5 U.S.C. 552A1, 5 U.S.C. 553A2, 31 CFR 1.3A4, and 26 CFR 601.702A2II. Lawful enforcement authority does not require implementing regulations only in the case of federal officers, agents, employees, and property. As we discussed earlier, 44 U.S.C. 1505A talks about that. It says, proclamations and executive orders, documents having general applicability and legal effect, documents required to be published by Congress. There shall be published in the Federal Register presidential proclamations and executive orders, except those not having general applicability and legal effect or effective only against federal agencies or persons in their capacity as officers, agents, or employees thereof. So they don't have to publish it in the Federal Register if it only pertains to the government. And for the purpose of this chapter, every document order which prescribes a penalty has general applicability and legal effect. So they cannot institute a penalty, an IRS penalty, against those parties who are not in the government unless they can produce implementing regulations. And we'll give you a hint. There is no such regulation. So they can't do it. And they have a burden of proving that you work for the government in order to do it. Lawful enforcement authority is only applicable within the territorial jurisdiction of the federal government, which means the federal zone, Washington, D.C., and the federal territories and possessions, and Admiralty maritime jurisdiction, and against domiciliaries of the District of Columbia when abroad. 26 U.S.C. 911, as we said earlier. The taxes imposed under 26 U.S.C. Section 1 and 26 U.S.C. 871 have no implementing regulations published in the Federal Register authorizing enforcement. Therefore, they can only be enforced against federal employees, officers, and agents, or against those engaged in a public office, e.g. the trade or business, acting on official capacity. See also 44 U.S.C. 1505A and 5 U.S.C. 553A, and that first one there is right up here. We showed it to you. They may not be enforced in states of the Union or outside of exclusive federal jurisdiction, period. And that's a function of what we call the separation of powers doctrine. The separation of powers requires a separation of legislative, civil, and criminal powers between the national government and the states of the Union. But what about illegal enforcement of income taxes? Because Subtitle A of the Internal Revenue Code is voluntary for persons domiciled in states of the Union who are non-taxpayers and who are not engaged in the trade or business, then the IRS cannot institute enforcement actions called distraint against anyone but public officers found in 26 U.S.C. 6331A, as we showed earlier, 26 U.S.C. 6671B, which is the definition of a person for penalties, and 26 U.S.C. 7343, which is the definition of person for criminal provisions or penal provisions of the Internal Revenue Code. And there are no implementing regulations published in the Federal Register authorizing enforcement actions within states of the Union against the general public. See IRS Due Process Meeting Handout, Form 03.008. You can take that to your next IRS audit if you'd like to educate employees, IRS employees, about that. And we also prove that in Great IRS Hoax, Form 11.302, Sections 5.4 through 5.4.27.7. And it isn't we, it's the Family Guardian website. They wrote that book. We didn't. No one can force you to sign or submit a tax return under Subtitle A. The IRS Internal Revenue Manual, Section 5.1.11.6.10 says IRS Form 1040, substitute for returns, are not authorized and therefore illegal. They can't do it. And every assessment they do against people who refuse to file is done in violation of that IRM section and the underlying statutes and regulations at 26 U.S.C. 6020. Enforcement actions include assessment authority. There are no implementing regulations that authorize assessment using Form 1040 for the tax imposed under Sections 1 and 871 of the IRC. Liens. They also can't do liens. IRS doesn't issue real liens. They issue notices of liens. Form 668YC is the form. And since the form is not signed by a judge as required by the Fifth Amendment, it need not be honored by its recipient. And we also showed that Section 6331 only authorizes that form to be filed against instrumentalities of the government. You're not an instrumentality of the government if you're a private human domiciled in a constitutional state and you're not engaged in a public office. Levies. IRS also doesn't issue real levies. They issue notice of levy on the Form 668AC DO. Since the form is not signed by a judge as required by the Fifth Amendment, it need not be honored by its recipient. It is only honored out of fear and ignorance by its recipient, but not out of a genuine legal requirement to obey. And criminal prosecution is also illegal. There are no implementing regulations for tax crimes and no federal agency with jurisdiction to investigate or prosecute them. These crimes only apply to federal employees or officers on official business, but have been misenforced to apply to private Americans who are not said employees, for which a civil rights action is warranted against the perpetrators. See Great IRS Hoax Form 11.302, Section 5.4.6. Continuing on with the illegal enforcement of income taxes, the Treasury Organization Chart reveals that the IRS is not an enforcement agency because it does not fall under the Undersecretary for Enforcement. And the IRS has no positive law, statutory, or regulatory authority to operate outside the federal zone and abroad. 26 U.S.C. 911 for Subtitle A income taxes. Since the states of the Union are not explicitly mentioned in the IRC, then they are excluded under the rules of statutory construction. See the definitions of the United States found in 26 U.S.C. 7701 A9 and A10, and the meaning of the words includes and including Form 05.014 on our forms page. IRS also has no enforcement authority against other than federal instrumentalities and public officers because 4 U.S.C. Section 72 requires all public offices to be exercised in the District of Columbia and not elsewhere except as expressly provided or enacted by laws of Congress. And IRC Subtitle A is primarily upon public offices, nearly all of which are in the District of Columbia, with very few exceptions. And 26 U.S.C. 7601 authorizes the IRS to canvass internal revenue districts for, quote, all persons therein who may be liable to pay any internal revenue tax, unquote. And there are no internal revenue districts any place but the District of Columbia. See 26 U.S.C. 7621, Executive Order 10289, and Treasury Orders 150-02 and 150-10. So if the IRS wants to enforce and they call you in for examination, you ought to demand proof that the activity they're trying to tax is exercised within either the District of Columbia or within an internal revenue district, and ask them for the proof of where these internal revenue districts are, because they don't exist. So how could they ever enforce outside of those districts that don't exist? Or even in a State of the Union for that matter. If there aren't any districts other than the District of Columbia, then how could they enforce anywhere but the District of Columbia? Hello? And they also have no enforcement authority against other than federal instrumentalities and officers because no enforcement regulations published in the Federal Register under Part 1 of 26 CFR, which is the income tax. See the following for a list of missing enforcement regulations. IRS Due Process Meeting Handout, Form 03.008. So there are so many holes in their enforcement authority, it isn't funny. And the ignorance of even tax lawyers on this subject is simply abysmal. And they also have no authority because the Federal Register Act, 44 U.S.C. 1505A, and the Administrative Procedures Act, 5 U.S.C. 553A, both say that statutes that have no implementing regulations published in the Federal Register cannot impose any enforcement penalty against the general public for noncompliance. And all employees, including collection employees, have administrative rather than enforcement pocket commissions. So they can't enforce, but they do, and they do so illegally. And Also, they have no enforcement authority because no jurisdiction to enforce criminal provisions of the IRC outside the federal zone and admiralty/maritime jurisdiction. And the Supreme Court said this in Carter versus Carter Coal Company, 298 U.S. 238. It is no longer open to question that the general government, unlike the states, Hammer versus Dagenhart, possesses no inherent power in respect to the internal affairs of the states, and emphatically not with regard to legislation. So the legislation just doesn't apply in the states. They have no civil or criminal enforcement powers within the states. And the crime, if they prosecute a crime, it has to be committed on federal territory. And if it isn't, then they are reaching outside their jurisdiction. And you should challenge jurisdiction when they do that. IRC Subtitle A is special law and private law that only applies to public officers and private individuals who have explicitly consented or elected to be treated as public officers engaged in the trade or business. We called that sort of law, private law and special law. We also called it class legislation, like the Supreme Court did in Pollock versus Farmers Loan and Trust, because that's what it is. It only applies to a subset of the general populace, and all of those people had to consent to be in that subset. And you should never consent. You're an idiot if you consent to be a public officer or a person or an individual or any status in the Internal Revenue Code. And you're not required to consent. And the fact that they call it voluntary means they're required to protect your right to not volunteer. And if they won't, they're liars and hypocrites. The Constitution does not authorize the regulation of private conduct of persons in states of the Union who are not public officers. And we've said this several times, but here's the proof. City of Bern versus Flores, Archbishop of San Antonio, 1997. The power to legislate generally upon the life, liberty, and property as opposed to the power to provide modes of redress against offensive state action, that is by public officers, was repugnant to the Constitution. And you read all these cases, they're all very interesting. And among those is a quote that basically says that a private person cannot execute or administer the law. Which is another way of saying that a private person cannot be a taxpayer, because you cannot be the subject of the law and therefore execute the law without being an officer in the government. And you can't be an officer, you can't be a private person and a private human and an officer in the government at the same time. It's an oxymoron. You know, there are only two kinds of things you can be in relation to the government. Three things. You can be a private human that's outside their jurisdiction. You can be a public officer who is a private human that is surety for an office, or you can be a public office, you know, like a corporation. Those are the only three things you can be. You always fall in one of those three categories. And if you're in the first category, a private human who is not serving in a public office and who has no contracts or agency with the government, then you are completely outside their jurisdiction and none of their laws apply. And that's what we teach people how to correctly represent in their administrative record, is the fact that they are not subject to those laws and therefore free and sovereign. So why is IRS enforcement lawful against government entities? Public employees, public officials, and public officers have no constitutional rights in the context of their official duties. And here's what the Supreme Court said on that subject. And this is why they can tax those people. And this is why the Internal Revenue Code effectively is a public officer kickback program. That's what we call it. The restrictions that the Constitution places upon the government in its capacity as lawmaker, i.e. as the regulator of private conduct, are not the same as the restrictions that it places upon the government in its capacity as employer. We have recognized this in many contexts with respect to many different constitutional guarantees. Private citizens, perhaps, cannot be prevented from wearing long hair, but policemen can. Kelly versus Johnson. Private citizens cannot have their property seized without probable cause. But in many circumstances, government employees can. O'Connor versus Ortega. Private citizens cannot be punished for refusing to provide the government information that may incriminate them, but government employees can be dismissed when the incriminating information that they refuse to provide relates to the performance of their job. Gardner versus Broderick. With regard to the freedom of speech in particular, private citizens cannot be punished for speech of merely private concern, but government employees can be fired for that reason. Connick versus Myers. Private citizens cannot be punished for partisan political activity, but federal and state employees can be dismissed and otherwise punished for that reason. And by the way, that word punished and the word penalties are synonymous. They cannot penalize you unless you work for the government. And we prove that in one of our forms. and as that we talked about earlier. And this is Rutan versus Republican Party of Illinois, 1990. So they can do whatever they want with their own officers and their own employees, including tax them. But if you're a private human and your property is exclusively owned and private, they have no jurisdiction over it. And if they have no jurisdiction over it, they can't tax it or they can't regulate it. That's the very definition and the essence of what private property is. It's property you own, that you exclusively own, that the government cannot regulate the use of. And if they can't regulate it, they can't tax it. If they can't tax it, they can't penalize you for not paying a tax on it. Public property managed by, let's see, those engaged in trade or business hold a public office and therefore public employees or federal contractors. That's what they are. 26 U.S.C. 7701A26 describes that. But see also why your government is either a thief or you are a public officer for income tax purposes, Form 05.008. We go into exhaustive detail to show you that the only way you could ever possibly be a taxpayer and be within the jurisdiction of uncle in a constitutional state, the only way you could be a taxpayer or subject to uncle's jurisdiction is to be a public officer, because that's the only way Federal Rule of Civil Procedure 17B allows them to reach you, because the separation of powers otherwise makes you foreign and alien legislatively. And furthermore, the Supreme Court declared in the license tax cases that they cannot offer or enforce any franchises within a constitutional state, which is precisely why the geographical definitions in the Internal Revenue Code limit themselves to the federal zone and exclude states of the Union. For that very reason, because they cannot offer franchises, and a public office is a franchise. Hello? Public property managed by public official contractors in the conduct of their duties belongs to the U.S. government. And the Supreme Court on this subject in Budd versus People of the State of New York defined the methods by which private property can become public property. Men are endowed by their Creator with certain unalienable rights, life, liberty, and the pursuit of happiness, and to secure, not grant, or create these rights, governments are instituted. That property, which a man has honestly acquired, he retains full control of, subject to these limitations. First, that he shall not use it to his neighbor's injury, and that does not mean that he must use it for his neighbor's benefit. Second, that if he devotes it to a public use, he gives the public the right to control that use. And third, that whenever the public needs require, the public may take it upon payment of due compensation. So federal contractors typically handle government property. They will build it, they will modify it, they will improve it under contract, and while they're in the possession of that property, they are effectively treated as public officers. Why? Because a public officer is legally defined as somebody who's in charge of the property of the public, and that's what a contractor is doing. He's modifying the property of the public, so he's in charge of the property of the public. And so what the courts like to do is presume that this federal contractor is an officer of the government and therefore a taxpayer, even though technically they can't elect themselves into office by contracting with uncle. And the Supreme Court also said in Osborne versus Bank of the United States that all the powers of the government are carried into operation by individual agency, either through the medium of public officers or through contracts made with private individuals. So in that particular case, they identified that agency is what Congress can reach. You have to be their agent before they can legislate for you. And you can be an agent either as a public officer or by having a contract with uncle. But if you have a contract, that doesn't make you automatically a public officer. You cannot, in fact, contract yourself into a public office. So technically, a federal contractor who is not a public officer cannot become one through the contract. Even though the courts violate that principle all the time, illegally and unconstitutionally, we might add. The method by which the public, who are the sovereign, controls private property donated to a public use is through the Internal Revenue Code. And as we said, all withholdings are gifts. That's how they're classified. So tax classified gifts, that's what they are. So effectively, property withholdings that are donated to the federal government, which is all withholdings, are donated to a public use to procure the benefits of a franchise. That's why you donate them, because you want the benefits of socialism. You want Social Security, you want Medicare, you want Medicaid, you want Obamacare, and any number of other things. But technically, that's an abuse of the taxing power, and technically those revenues are not taxes, as we showed earlier. The tax must be paid only to the government. It cannot be paid to private parties. And if you really want to get somebody into a corner, let them prove that you're qualified to receive those payments and that you are a public officer, because you aren't. And if you're not qualified to receive those payments, then you're also not qualified to be a taxpayer to begin with. Hello? So why is IRS enforcement lawful against government entities? IRS does not need enforcement regulations published in the Federal Register for federal instrumentalities, such as employees and public officers. This is confirmed by 44 U.S.C. 1505A1, as we showed earlier, 5 U.S.C. 553A, 31 CFR 1.3A, 26 CFR 601.702A1, and 26 CFR 601.702A2II. The requirement for the publication of implementing regulations in the Federal Register originates from the constitutional requirement for reasonable notice to the public of the laws they are expected to obey, as indicated in 26 CFR 1.3a and the Supreme Court in these following two cases. They said, it is sufficient to say that there are certain immutable principles of justice which inhere in the very idea of free government, which no member of the Union may disregard, as that no man shall be condemned in his person or property without due notice and an opportunity of being heard in his own defense. So you have to be noticed of what you're required to do before they can enforce the obligation. And it never has been doubted by this court or any other, so far as we know, that notice and hearing are preliminary steps essential to the passing of an enforceable judgment, and that they, together with a legally competent tribunal, have jurisdiction of the case, constitute basic elements of the constitutional requirement for due process. More reasons why IRS enforcement is lawful against government entities. Publication in the Federal Register satisfies the requirement for reasonable notice because it incorporates a public notice and comment process prior to publication. See Requirement for Reasonable Notice, Form 05.022 on our forms page. And it is not a violation of the Fifth Amendment for the U.S. government to reclaim public property that always was theirs without payment of just compensation, because public officers are not protected by the Fifth Amendment in the context of their official duties. This is why the IRS can lawfully levy pay and benefits, because they are actually federal property managed by public officers in the conduct of their official duties. And that's reflected on the levy form itself, and also in section 6331A. It says levy may be made upon any office or instrumentality of the national government, and by implication it may not be made on any private human being. And lien, chattel, and real property, because IRS is recovering funds that have been mismanaged by a public official in the conduct of his or her official duties. It's also lawful for IRS to enforce against government entities because the IRS and judges will try to convince you that the above is not the case, but they are lying to maintain the flow of plunder into their checking account and their retirement account in violation of 28 U.S.C. 455, 28 U.S.C. 144, and 18 U.S.C. 208. If you'd like to know more about this subject of why it's lawful to enforce only against instrumentalities of the government and not against private humans, see Federal Enforcement Authority and States of the Union, Form 05.032, Public versus Private Employment, you really work for Uncle Sam if you receive federal benefits, and Resignation of Compelled Social Security Trustee, Form 06.002. So the bottom line is that if a judge or an IRS is calling you a taxpayer, they're making a presumption that you must rebut. What the government will freely admit is that the defendant is a taxpayer. What the rest of the story, however, is that because he mixed his private property, including his labor, his financial assets, with government property in the form of Social Security number, 20 CFR 422.103D says that the number is the property of the government. It is illegal to use public property for private use because it's called embezzlement. Because he did this, and we give him the benefit of the doubt that he is not an embezzler who is engaged in a criminal activity violating 18 U.S.C. 641, then the only other thing we can assume is that he is a public official on official business managing private property donated to a public use to procure the benefits and privileges of socialism, social insurance, and government idolatry. That's what's happening. If you act like a duck and you quack like a duck, and a duck is a public officer, then you're going to be treated like a duck. And nobody's ever going to argue with you about whether you're a duck, because they make all their cash and all their money and all their bloated benefits from that fraud. And they're never going to jeopardize their revenues, now are they? Because the love of money is the root of all evil, isn't it? If you use a government identifying number, then you're a government entity. Don't use government identifying numbers. See about SSNs and TINs on government forms and correspondence, Form 05.012. There are very specific requirements for when a number should be used. And none of those requirements pertain to a private human. They only pertain to public officers in the government, because the government can't regulate private conduct. If you act like a duck and you quack like a duck and waddle like a duck, then by golly, you're a duck, regardless of what you say you are. Quack, quack, quack. Keep on quacking. They illegally harass, threaten, and terrorize people who don't want to quack. However, IRS enforcement against other than public employees or public officers or public property is illegal. Those who do not hold a public office or who are not engaged in a trade or business and who have no earnings from the District of Columbia or the U.S. government may not lawfully be the target of IRS enforcement actions. And the property of those not engaged in a trade or business is not public property or property devoted to a public use. Therefore, it may not be administratively levied, liened, or taken from them in a court of law through due process without just compensation. And here's what the Supreme Court said on that in Hale versus Henkel, 1906. The individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way, that is unregulated by the government. His power to contract is unlimited. He owes no duty to the state or to his neighbor to divulge his business or to open his doors to an investigation so far as it may tend to criminate him. He owes no such duty to the state, since he receives nothing therefrom beyond the protection of his life and property. His rights are such as existed by the law of the land long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are a refusal to incriminate himself, and by we might add on a tax return as well, and the immunity of himself and his property from arrest or seizure except under warrant of law. He owes nothing to the public, including so-called taxes under Subtitle A of the IRC, so long as he does not trespass upon their rights. So my question to any judge is that they're talking about here is a private citizen who has constitutional rights, and that's synonymous. You cannot be private without having constitutional rights, okay? And a person who is a public officer or an instrumentality of the government or a federal corporation has no such constitutional rights and isn't even a person or a citizen, for that matter, under the Constitution. So they're only talking about private humans here. And they're saying that he owes no duty, nothing, including the duty to file the tax return. So obviously, there's what we would call an Orwellian doublethink going on here. On the one hand, they'll call you a taxpayer, and they'll say you have to file a tax return, and refuse to define what they mean by taxpayer. And then on the other hand, they'll say that humans don't have to do this. You can't have it both ways. And where the two ends of that Orwellian doublethink meet is that, as we said, the tax is on the office. The taxpayer is the public office. And the public officer, or the human, the private human, has to volunteer to become surety for the office. And he has to do so through an oath, and he has to be lawfully appointed or elected, and he can't fill out a government form, including a tax form, to elect himself into office. So you have to be an officer of the government before you can become a taxpayer. And anybody who files a tax information return upon those who do not satisfy that criteria is filing a false return. They are conducting essentially an election of you into public office without your knowledge. And they're using the fruits of that false election and that crime as a method to further other crimes of tax enforcement against those who are not subject. So, and as we said before, any evidence generated in the process of effecting that fraud, that crime of impersonating a public officer, is the fruit of a poisonous tree and cannot be used lawfully to prosecute any other crime. You cannot use one crime to create and prosecute another crime based on that crime. That's ridiculous. So how do you know what constitutes public property for the purposes of lawful liens and levies? Property devoted to a public use or a public purpose that may lawfully be levied under Section 6331 without a court order and without violating the Fifth Amendment includes earnings from labor that are subject to W-4 voluntary withholding agreements, financial accounts that were opened with a Social Security number or taxpayer identification number, or property against which tax deductions were taken under 26 U.S.C. 162. Only those engaged in a trade or business may take any kind of deduction, and that's under Section 162. Therefore, non-resident aliens may not take any tax deductions on a 1048-R for any earnings not connected with a trade or business. And when you think about it, you really don't need deductions if you don't earn income, do you? The only reason you need deductions is because you have reportable income, and you can't have reportable income without trade or business earnings. So if you're not engaged in a trade or business, you don't have any income, so you don't need deductions. Duh. Jurisdiction of the federal courts over federal income taxes. Federal district courts have jurisdiction over all federal property, contracts, and franchises. This jurisdiction is conferred by Article 4, Section 3, Clause 2 of the Constitution. Internal Revenue Code Subtitle A is private law and contract law, or agreement law, however you want to describe it. It is, as we said, class legislation that only pertains to a subset of the population engaged in a public office or federal agency of some kind, and a federal franchise that makes its beneficiaries into public officers engaged in a trade or business. See the trade or business scam, Form 05.001. We prove that they're abusing, misrepresenting, and misenforcing the Internal Revenue Code to make it apply to private humans who aren't subject, and they're doing it so they can steal from people, and they're engaging in treason, eminent domain without compensation, a Fifth Amendment taking, impersonating a public officer, conversion of private property to public property without the consent of the owner, and on and on and on and on. There's no end, and it's all money laundering. Every time they accept a withholding or any kind of payment, they're engaging in money laundering, because all you have to do is prove that you have to be a criminal to be a taxpayer, and beyond that point, everything is money laundering. And it's a crime to impersonate a public officer, and if you're not a public officer, you can't be a taxpayer. Information returns constitute prima facie evidence of involvement in the trade or business franchise, 26 U.S.C. 6041, as we showed earlier. And the use of the Social Security number creates a prima facie presumption that you are engaged in this federal trade or business franchise. See Resignation of Compelled Social Security Trustee, Form 06.002. The franchise agreement consists of 26 U.S.C. Subtitle A, the Internal Revenue Code, and 42 U.S.C. Chapter 7, the Social Security Act. Unless you rebut the usually false presumption that you are engaging in the franchise by rebutting the information returns and the Social Security number and opening all your financial accounts as a non-resident alien without numbers, then the federal courts will silently presume that you are a taxpayer subject to the IRC who consented to procure the benefits of the franchise. So they're rigging the system to make you look like that which you're not. And you could say that the system is rigged to conduct essentially institutionalized identity theft, to convert you into a public officer, or at least to make you look like one, and to enforce the obligations of that office upon you. Because as they said in Hale versus Henkel, the private citizen owes nothing to the government. So, and the taxpayer owes everything to the government. The taxpayer is a creation of the government. So you can't be both. You cannot be a private citizen and a taxpayer at the same time. It's an oxymoron. It's Orwellian doublethink, for that matter. So the jurisdiction of the federal courts over federal income taxes. Question: how did you become subject to the IRC and the federal courts? California Code indicated how. In the case of franchises, a voluntary acceptance of the benefits of a transaction is equivalent to a consent to all the obligations arising from it, so far as the facts are known or ought to be known to the person accepting. So if you accept the benefit, then you're presumed to accept all the obligations that go with delivering the benefit, aren't you? However, if the Declaration of Independence says your rights are unalienable, and that declaration is organic law published in the Statutes at Large in the very first enactment of Congress, then you can't give away your rights even with your consent. And so you cannot consent to receive a benefit. And therefore, if you didn't consent to receive it, then it must be a gift. And if it's a gift, you're not a taxpayer. You can't be a taxpayer. The only way they can make you a taxpayer is if it's a loan. They have to loan you their property and with conditions before they can impose an obligation on you. And the great hypocrisy of all this is is what we showed you earlier. We showed you that tax withholdings are gifts to the government, so everything you pay them is treated as a gift, and yet they turn around and when they want to pay that same money that you gifted to them back to you or anybody else, they place conditions on it and make it into a loan rather than a transfer or an exchange. And so essentially essentially what they give you can never be classified as a gift, but everything you give them is a gift. So in other words, they're diodes and check valves. They use everything they have to enslave you and to create obligations and to loan things to you on conditions, and yet you're not allowed to do that to them. Now, does that sound like a title of nobility? An unconstitutional title of nobility in violation of Article 1, Section 10 of the Constitution? Sure does to us. You know, if they're going to treat everything we give them as a gift, then we ought to be able to treat everything they give us as a gift, right? And if they do, then, and if our rights are unalienable, as the Declaration of Independence, which is organic law and law, says, then there's no way, essentially, that anything they give us could ever be loaned to us or ever be anything but a gift, right? Because everything we pay them is a gift. So everything they pay us should be a gift as well. And I would insist on that at all times. And that would ensure that you would never be subject to any conditions they might place on the giving of their property. Because they really don't generate any revenues of their own. All they do is steal from people by lying to them. And then they use the money that they stole as a way to recruit more public officers and taxpayers and sponsors. So they're using stolen money to illegally create new public offices and taxpayers, and to bribe voters and jurists and judges with to have their way with them. So the answer is you accepted the benefits of the franchise, is what they would say, even though we know you can't do that under the Declaration of Independence. You accepted the contractor compensation in the form of trade or business deductions under 26 U.S.C. 162, a reduced or graduated rate of tax under 26 U.S.C. Section 1 instead of a flat 30% in the case of non-residents under 871A, and you accepted earned income credits under 26 U.S.C. Section 32. All of those are, quote, benefits, and they are commercial benefits. But guess what? If you never were a public officer, none of those really are benefits, are they? They're not. If you're not a public officer, then it would not be a benefit, and therefore you have no earned taxable income or gross income. Then none of those deductions or reductions in your obligations would have any effect at all, would they? So they're not really benefits if you're not already a taxpayer and a public officer in the government. So you became eligible for, the answer is, the benefit is, you became eligible for socialist, what we call socialist insecurity. See Resignation of Compelled Social Security Trustee, Form 06.002, Medicare, unemployment compensation, and or Obamacare for that matter. But the question is, where is the consent to the agreement? You can't elect yourself into a public office, and you can't be subject to those civil franchises without being an officer of the government, because they cannot pay public money to private people, now can they? We already established that in Loan Association versus Topeka. For those who accepted the benefits, the IRC and the Social Security Act are law. And we already said the only people who can lawfully accept those are people who already work for the government, which means nobody in a state of the union who is not already a public officer, an elected or appointed public officer for that matter. For those who didn't, it isn't and is as foreign as the laws in China are to the average American. The law is the contract. And we should really say here the code is the contract, because technically it's not law if it requires our consent. It's only law if it doesn't require our consent. And you have to be if you have to be a public officer before you can be a taxpayer, then your consent was required. And therefore, technically, it's private law or special law or class legislation. And here's the definition of that private law. That portion of the law which defines, regulates, enforces, and administers relationships among individuals, associations, and corporations. As used in contradistinction to public law, the term means all that part of the law which is administered between citizens and citizen, which is concerned with the definition, regulation, and enforcement of rights in the case where both the person in whom the right inheres and the person upon whom the obligation is incident are private. Now, why would we use private law to describe that which is enacted by Congress? because the Internal Revenue Service is not an agency of the government. It's not in the Treasury Department. It is a private corporation. And it has no legislative authority to exist. And you can scour the Treasury website all you want, and you'll find out the IRS is not part of the government. It never has been. Congress never even created the IRS. They never even created the name IRS, as a matter of fact. And that name has changed over the years. So it's a private corporation is what it is. It's a debt collector for Uncle under contract. And as a debt collector, anything you arrange between yourself and them is private law because you're private and they're private. The U.S. Supreme Court has said that every citizen is supposed to know the law. Therefore, you receive reasonable, constructive notice of the terms of the contract. Every citizen of the United States is supposed to know the law. Every man is supposed to know the law. A party who makes a contract with an officer of the government without having reduced it to writing is knowingly an accessory to a violation of duty on his part. Such a party aids in the violation of law. Clark versus United States. Don't believe us? Read the truth for yourself. Requirement for reasonable notice, Form 05.022. What about tax crimes? They are identified in 26 U.S.C. 7201 and 7217. Now, we want to qualify this. They aren't technically tax crimes because you have to be a public officer to commit them, and you have to volunteer to be a public officer. So technically, the Internal Revenue Code is a franchise, and all franchises are contracts and or agreements. And so technically, they are penal provisions of a franchise, these provisions. They're penal provisions, and they're penal in that sense, if the IRC is an agreement or a contract, by calling yourself a taxpayer and availing yourself of the, quote, benefits and privileges, unquote, of being a taxpayer, essentially you're consenting to an agreement to make you into temporary federal property to be housed in a warehouse called a jail. So, but you're not a criminal. They will try it as if it were a criminal case, but technically it isn't. Why? Because a prerequisite to any kind of tax liability is a domicile. And without a domicile on the federal zone, you cannot have a status under their laws. And if you can't have a status, then you can't be a taxpayer or a citizen or a person or an individual. So first you need a domicile. And that's and a domicile is a civil issue. So you must be subject to the civil jurisdiction before any of the tax crimes can even activate, or the penal provisions. So technically, since a tax liability is a civil liability, and it's a liability under the civil statutory law, which is a civil franchise. So they cannot make it into a criminal provision because it has a civil prerequisite. It can't be both. It can't be. It's either civil or it's criminal. If it's both, then it's technically it's civil. So facts about tax crimes. There are no implementing regulations, which means they only apply to federal employees, contractors, and agencies listed in 44 U.S.C. 1505A1 and 5 U.S.C. 553A. And no agency has investigative jurisdiction. See U.S. Attorney Manual 9-4.139 and Great Irish Hoax Form 11.302, Section 5.4.10, which clearly proves this. And the criminal laws of any jurisdiction only apply within its territory. And they frequently try to prosecute so-called tax crimes in federal court against people who aren't domiciled in the statutory United States or in federal territory, and who are instead are domiciled in states of the Union. And effectively what they're engaging in when they do that is acts of international terrorism, because the states are nations under the law of nations in many particulars as ruled by the Supreme Court. And therefore, to kidnap somebody from that jurisdiction and hold them accountable for laws that don't apply in that jurisdiction, and using a so-called franchise contract as the only basis for doing it, and refusing to even admit that it's a contract or an agreement, or that it requires consent to be applicable, is fraud. So they're engaging in acts of international terrorism, and in that context, the District of Criminals, as Mark Twain calls it, is a haven for financial terrorists. And all these bogus notices of lien and notices of levy are the paper terrorism that are being entered into the county courthouses across the country illegally, And they can't file those outside of an Internal Revenue District. That's what it says in Section 7601 of the Internal Revenue Code. They cannot enforce outside of an Internal Revenue District. And the only district is the District of Columbia, and therefore they can only file those notices in the District of Columbia and not elsewhere under Section 4 U.S.C. Section 72. And that's consistent with the definition of United States in 26 U.S.C. 7701 A9 and A10. It's consistent with the definition of United States in the Uniform Commercial Code, and on and on and on. And they have no comeback for any of this. They'll simply try to ignore it and hope that you don't notice it. But you shouldn't let them get away with that. You ought to vociferously argue those issues. And by the way, let me emphasize here that we are not saying that the taxes only apply in the District of Columbia. They can apply extraterritorially to a public officer anywhere. But the key is that public officer must be lawfully serving. And very few of the people who they enforce against fit that category. Okay? A public officer can serve in a State of the Union, for instance, and he can even be a taxpayer, but only if his office is authorized to be exercised outside the District of Columbia in the specific state where he's being collected against, and only upon his pay as a federal officer and not as a private human. So they cannot conduct the enforcement against the private property or private rights. Because why? Because the ability to regulate private property and private rights is repugnant to the Constitution, as we said earlier. So, facts about tax crimes. States of the Union are not territory of the United States and therefore are not subject to the criminal laws of the United States. And this was very clearly shown in Rule 54C of the Criminal Rules of Criminal Procedure, Federal Rules of Criminal Procedure, and they very conveniently took it out. They didn't repeal it, they just took it out when they revised Rule 11 to hide that fact. But it's still the truth that federal crimes cannot be prosecuted outside of federal territory. And that's, if you look at the earlier versions of Rule 54C, you will see that. The prerequisite that all federal tax crimes is willfulness. Willful, proceeding from a conscious motion of the will, voluntary, knowingly, deliberate, intending the result which actually comes to pass, designed, intentional, purposeful, not accidental or involuntary. Premeditated, malicious, done with evil intent or with bad motive or purpose, or with indifference to the natural consequence, unlawful, without legal justification. An act or omission is willfully done if done voluntarily and intentionally and with the specific intent to do something the law forbids, or with the specific intent to fail to do something the law requires to be done. That is to say, with bad purpose either to disobey or to disregard the law. It is a word of many meanings, with its construction often influenced to its context, Screws versus United States, 325 U.S. 991. A willful act may be described as one done intentionally, knowingly, and purposefully without justifiable excuse, as distinguished from an act done carelessly, thoughtlessly, heedlessly, or inadvertently. A willful act differs essentially from a negligent act. The one is positive, the other is negative. For details on what constitutes reasonable belief about tax liability and how to avoid a charge of willfulness, see our free pamphlet, Reasonable Belief About Tax Liability, Form 05.007. U.S. attorneys do not have the delegated authority to investigate tax crimes under 26 U.S.C. 7201 through 7217 because there are no implementing regulations authorizing them to do this against other than federal instrumentalities, employees, and public officers. So, yes, they can investigate it if a federal officer did not pay his taxes, but not if a private human didn't. They may not prosecute or defend tax crimes outside the District of Columbia, see 4 U.S.C. Section 72 and Treasury Order 150-02, and they don't have the legal authority to defend IRS agents involved in misconduct or who violate the Internal Revenue Code or who are sued by citizens, see U.S. Attorney Manual 6-4.200. So let's move on to a new subject, state income taxation. It's described on our site in our Memorandum of Law entitled State Income Taxes, Form 05.031, available on our Forms page. It's also described in Chapter 4 of the Tax Fraud Prevention Manual. Additional information is available at the State Response Letter page, Form 07.201, on our website, in our Forms page. And the following states do not have state income taxation: Alaska, Florida, Nevada, New Hampshire, South Dakota, Tennessee, Texas, Washington, and Wyoming. The reason that state income taxes don't violate constitutional rights is because they are based on federal liability first, and there are no constitutional rights within the federal zone, which is the only place they can be administered. That's why we referred earlier to the phrase in this state or the state as being federal territory within the jurisdiction or boundaries of a constitutional state. And the only way you can be liable is if you volunteer, and at least theoretically, what you volunteer for can't hurt you under the common law. Now, within states of the Union, there are two jurisdictions, just like there are within the federal venue. There are two states within each state of the Union. The Republic state, land within the exclusive jurisdiction of the state, falls in this area, and the corporate state. This area consists of federal areas within the exterior limits of the state. These areas are federal territory not protected by the Constitution of the United States or the Bill of Rights and are instrumentalities of the federal government. Jurisdiction over these areas is shared with the federal government under the auspices of the following legal authorities: the Buck Act, 4 U.S.C. 105 through 111, the Agreements on Coordination of Tax Administration or ACTA agreements between the state and the Secretary of the Treasury, see Section 7 later, and the Assimilated Crimes Act, 18 U.S.C. 13, and 28 U.S.C. 2679C, which says that any action against an officer or employee of the United States in which the officer or employee is acting outside their authority shall be prosecuted in state court, and the Rules of Decision Act, 28 U.S.C. 1652. This act prescribes which of the two conflicting laws shall prevail in the case of crimes on federal territory. For more information on the choice of law rules governing which of these two jurisdictions you are in, see Sections 2 and 3 of the following. Federal Jurisdiction, Form 05.018. There are no constitutional rights or protections within the corporate state, meaning federal territory. Why? Because the Constitution attaches to land, not to the status of the people on the land. So federal areas within constitutional states are technically subject to exclusive federal jurisdiction and therefore are not protected by the Bill of Rights or the Constitution. And that was pointed out in the case of Downs versus Bidwell of the Supreme Court. Everything within the corporate state is a franchise and a privilege that is taxable and regulated. If you are born within and domiciled within a republic state, you can only join the corporate state by your tacit or implied consent in some form. We join the corporate state by consenting to become a public officer, and doing so lawfully, we might add. And at that point, we are representing a federal corporation, which is the United States. See 28 U.S.C. 3215A. We become officers of a corporation subject to the penalty provisions of the IRC at 26 U.S.C. 6671B. And we become officers of a corporation subject to the criminal provisions of the IRC, 26 U.S.C. 7343. And we are subject to the laws in the place where the corporation was incorporated pursuant to Federal Rule of Civil Procedure 17B and 26 U.S.C. 7701A39 and 26 U.S.C. 7408D. Remember, all federal corporations are statutory U.S. citizens, and therefore we become a statutory U.S. citizen while representing U.S. Inc. as public officers. 2 states within each state of the Union. So how do we consent to become a resident alien domiciled within the corporate state and therefore a taxpayer? Remember, we said earlier that a resident is really just somebody engaged in a public office. And the office is domiciled in the District of Columbia, so that's how we become resident in the District of Columbia. So how do we become a resident domiciled within this corporate state and therefore a taxpayer? And here are all the ways. Accepting federal employment or federal public office. See why your government is either a thief or you're a public officer for income tax purposes, Form 05.00A. Or applying for any federal or state benefit or program, such as Social Security, Medicare, or FICA. And for proof, see Resignation of Compelled Social Security Trustee, Form 06.002. But we want to add here that you cannot lawfully apply for those or receive any of the benefits unless you're occupying a public office or lawfully occupied an office at some point in time, and those benefits should be proportional only to the time you spent as such officer. You cannot do so as a private human, because that, as we said before, would be an abuse of federal powers of taxation to pay private parties and transfer wealth, and they're not allowed to do that. Another way that you become a resident domiciled within the corporate state is to apply for any kind of government license or privilege, including a driver's license. You can't legally apply for or receive a state driver's license without domicile in the corporate state. Why? Because they ask for a social security number. And the only people who can use the number are public officers on official business. You cannot use public property for a private purpose. That's theft. And we prove that in Defending Your Right to Travel, Form 06.010. Marriage licenses are another example of a franchise. Marriage is a third thing of common right according to the courts. Therefore, it can only be licensed in places where constitutional rights do not exist, such as federal zone or the corporate state. See Sovereign Christian Marriage, Form 06.009. Another way is to use a Social Security number or taxpayer identification number in connection with any of our private financial affairs. All such numbers belong to the government. You cannot lawfully use such a public property without being a federal employee or a public officer. How do we know that? Because if we look in the regulations at 26 CFR 301.6109-1, it lists all the conditions under which the use of the number is mandatory. And you cannot use the number unless you're engaged in a public office in the government, a trade or business, or an activity that is required to be exercised by a public officer. State versus federal income taxation. State and federal legislative territorial jurisdictions are mutually exclusive. This is a result of the separation of powers doctrine. See the separation of powers on the Family Guardian website, and government conspiracy to destroy the separation of powers, Form 05.023. All income taxes are based on legal domicile, and you can only have a legal domicile in one of two jurisdictions at the same time, state or federal. All state income tax liability has federal liability as a prerequisite, and all federal income taxation presumes a legal domicile on federal territory and without land under the exclusive jurisdiction of your state. Therefore, if you do not have a legal domicile on federal territory and are not representing a business entity that does have such domicile pursuant to Federal Rule of Civil Procedure 17b, then you are a non-taxpayer not subject to the IRC Subtitle A, who has no requirement to file the tax return. Now, this is also equivalent to what we said earlier. We said that you have to have a domicile in a place to have a civil status in that place, and that status includes a taxpayer or person or individual. So if you're not domiciled in a place, then you can't have a status under the laws of that place, at least without a contract with the entity governing that place. And if you can't contract your rights away as a state citizen under the Declaration of Independence, then you cannot consent to any such status in that foreign jurisdiction, even with your consent. So you cannot maintain or preserve any status under federal law in such a foreign jurisdiction as a state citizen. State income taxes are based on the Buck Act, found in 4 U.S.C. 105 through 111. State income taxes imposed under the authority of 4 U.S.C. Section 106, state and so forth, taxation affecting federal areas, sales or use tax, income tax, and 5 U.S.C. 5517, which is withholding state income taxes. So, and those states are federal territories. And what's happening is that constitutional states are acting like federal states under these provisions so that they can illegally receive the plunder of the tax from the federal government through essentially, sharing programs or benefit programs of one kind or another. Because the federal government does the same thing to the states that they do to you. They try to entice you into a franchise or a benefit, and in the process of you signing up, you become basically a federal territory as a state, and you surrender your sovereign immunity and so on. And that's exactly what happened in the case of Obamacare, because when the states petitioned the Supreme Court because they thought they weren't subject to Obamacare, what did they do? Instead of going straight to the Supreme Court like they were supposed to under the Constitution, they filed initially in the district court. Now, well, why did they do that, and how did they do that? Well, a district court can only hear matters involving federal property or federal territory, unless it's a constitutional issue. And Obamacare is a federal legislation that only applies on federal territory. So why are they arguing about whether federal territorial law applies within the boundaries of their state to people who are not on federal territory? And the answer is because once they signed up for Obamacare, if they signed up and they signed up for an exchange, then they essentially became officers of the national government in administering this program because they're availing themselves of the benefits, privileges, and protections of a franchise offered within their state. And as a consequence, they consent to all the benefits. As a recipient of those benefits, they consent to all the obligations needed to deliver the benefits. As the Supreme Court has held over and over that has to be the case. So what they're doing is they contended Obamacare in a district court because they knew that they had no standing as a constitutional state. So they had to act like a corporate state and like uncle's property as a federal corporation before they could do anything to get a remedy. Really, all they had to do was file their original action in the Supreme Court and claim to be a state and insist that they didn't want Obamacare enforced in their state. And at that point, the Supreme Court would have to rule that it's unconstitutional. But they didn't do that. They spoke out of both sides of their mouth like most serpents do. You know, they didn't want to lose the benefits of all these profit sharing or plunder sharing programs of the federal government. And so they didn't want to challenge the applicability of federal law or bribes to them, but at the same time, they didn't want the obligations. You know, you can't have it both ways. Either you're a dependent of uncle, or you're sovereign and self-governing and self-supporting. You can't have it both ways. That's why we tell people, you know, you cannot receive benefits or consent to receive benefits and at the same time claim to be independent and sovereign. It's one or the other. The state referenced in the above statutes is a federal state, which is defined in 4 U.S.C. Section 110D as a territory or possession of the United States. And here's the definition. And notice it defines the states, and that's the same phrase, the states, that appears in the definition of United States found in 7701A9 and A10. So it says the term state includes any territory or possession of the United States. Federal areas or enclaves within states of the Union are technically possessions of the United States and fall under the exclusive control of the federal government under Article 4, Section 3, Clause 2 of the Constitution of the United States. States of the Union do not qualify as statutory states, quote unquote, within the meaning of the Buck Act above. Those who file and sign only Federal Form 1040 are claiming that they are any one of the following: aliens or residents or resident aliens who live in a federal possession. See Great IRS Hoax Form 11.302, Sections 5.5.2 and 5.5.3, or U.S. citizens working overseas but not in the State of the Union under 26 U.S.C. 911. And by U.S. citizens, we mean statutory citizens. We don't mean constitutional citizens. And once again, you cannot be a constitutional citizen and a statutory citizen at the same time. They are mutually exclusive. And U.S. persons under 26 U.S.C. 7701A30. See Great IRS Hoax Form 11.302, Section 5.4.12. Or taxpayers who earn taxable income and gross income. If you don't have a federal income tax liability under Subtitle A of the Internal Revenue Code, it's impossible to have a state liability because the situs for taxation is the same for both state and federal income tax purposes. They both have to assume that the domicile of the taxpayer is in a single place and that it is on federal territory not protected by the Constitution. Why? Because, as we said, the taxpayer is the office and not the officer or the human filling the office. Okay, and that office is domiciled on federal territory in the District of Criminals, as Mark Twain calls it, and therefore is within the exclusive jurisdiction of Congress. Most state income tax laws use exactly the same definitions as those found in the Internal Revenue Code, and you can see that for yourself on the link provided there. States need permission from the Secretary of the Treasury of the United States to assess or collect IRC Subtitle A income taxes. States must sign an agreement on coordination of tax administration, or ACTA, pursuant to 26 U.S.C. 6361 through 6365 and 26 CFR 301.6161-1 through 301.61-65-2 in order to obtain authority to collect on federal territory within the corporate state. So when they enforce a state income tax, the area they're collecting over is the federal enclaves within the state and not any other land within that state. And if you file a resident tax form for the state tax, then you are creating a presumption that you are domiciled there on federal territory within the exterior limits of the state. And because they have a tremendous windfall of plunder coming into their checking accounts through that simple mistake on your part, they are never going to point that mistake out to you. They will never penalize you for it. And so that's consistent with a Chinese proverb that says the mouth which eats does not talk. So as long as they're eating your substance and your property, your private property, because they fooled you into filing a tax return you weren't supposed to file, they're never going to fix the problem, because the love of money is the root of all evil, and they'll just shut up. And if you ever do find out what the truth is about what you're supposed to do, and you bring it to their attention, they'll say, oh, well, you weren't supposed to trust anything we said. We told you couldn't trust our publications or our forms or anything we told you on the phone. We even told you couldn't trust what your attorney says. You can't trust what a public officer and any government says. So shame on you for trusting our publications. We warned you. That's completely unethical. So IRC Subtitle A, the permission they need gives the state permission to collect income taxes in federal areas within the exterior boundaries of the state. And the reason federal permission is necessary for states to collect is because the power of taxation within federal possessions is plenary and resides exclusively with the federal government, but the federal government only may consent to allow states to tax there as well under the rules of comity. So in other words, if the taxpayer is the office and they created the office and they own the office, then you need the permission of the creator of that office, the owner of the office, to impose duties upon that office. And under the Buck Act, that's exactly what the federal government did, is it consented to allow officers of the national government to be taxed by the state governments if they are physically serving in their office on federal territory within the exterior limits and no place else. And furthermore, the national government cannot consent to allow the states to tax an office that is not exercised on federal territory. There's no authority for that. Why? Because federal law does not apply outside of federal territory. The ACTA agreements, in turn, are an incentive for the states to collude with the national government in allowing or acquiescing to illegal collection of federal income taxes by the IRS in areas that are outside of the federal areas within the state. It's all about money, and as long as the state gets its cut, then it looks the other way, while the federal beast rapes, pillages, and extorts money from those who aren't liable. And these agreements are a big secret, and you will find it difficult to get a copy of one for your state. And if revealed and used to litigate against the states, would blow the lid on the state income tax fraud, because that's what it is. It is a serious mistake to file a state income tax return and assess a liability if you either aren't filing a federal tax return or have no federal liability. Under the Fed-State program, state and federal governments share electronic information about you, and they will snitch on you. The Internal Revenue Manual, Part 11, Chapter 4, Section 1, for details. And if the federal and state databases don't match, you could be wrongfully prosecuted for fraud or, worst yet, tax evasion. And here's an example in California. The personal income taxes are described in the Revenue and Taxation Code, Section Division 2, Part 10. And the taxes imposed in Section 17041 on residents of this state. And notice we put that in quotes. And the term "this state" means the federal areas within the state. It does not mean the whole state. It does not mean the place where most people live in the state. It means people in the federal areas, like the national parks and the shipyards. That's all. The definition of state in the California Revenue and Taxation Code, Section 6017. In this state or in the state means within the exterior limits of the state of California and includes all territory within these limits owned by or ceded to the United States of America. So it's federal territory. And that section 6017, is the definition of in this state for the purposes of sales taxes. So they can't even enforce sales taxes outside of federal territory within the exterior limits of the state. And 17018 is the definition of state for the purposes of income taxes. And it says state includes the District of Columbia and the possessions of the United States. And those possessions are the federal areas within the exterior limits of the state. Only non-residents of the state are subjected to income tax. See California Form 590 for proof. And California Form 540 tax return on line 12 says state wages from your forms W-2 or box 17. Okay? But the important thing to remember here is they're talking about wages, and you cannot earn wages unless you're engaged in a public office in the national government. So you cannot therefore be a taxpayer under state law without being an officer of the national government and without be serving in the federal enclaves within the exterior limits of the state and without lawfully being appointed or elected, because you can't elect yourself into office with any form, any tax form. The only earnings from labor that go on Form 540 are those which are earned in federal areas within the state and constitute wages, which may only be earned by federal employees or officers, we might add, who have a voluntary withholding agreement in place called the W-4 as required under 26 CFR 31.3401A-3A or 3402P for that matter. If you want to know more about your state's income taxes, you can find lots of resources on our website about that subject by looking in the following areas: state income tax response letters, Forms 07.201 on our forms page, state legal resources on the Family Guardian Sister site, state income tax information on the Family Guardian Sister site, state income tax forms on these two links, and tax fraud prevention manual, Form 06.008, Chapter 4. Details about your state's usually fraudulent approach towards personal income taxes. Let's move on to another subject, flawed tax arguments. If you intend to use any of this information in your own case, it is very important that you read all of the following analysis of the many flawed tax arguments out there from the government, legal profession, and other groups. Flawed tax arguments to avoid, Form 08.004 on our forms page. Meaning of the words includes and including, Form 05.014. This is how they illegally expand definitions to apply them outside their jurisdiction and outside their territory. Rebutted version of the IRS's The Truth About Frivolous Tax Arguments, Form 08.005. This shows you all the lies the IRS will tell you in rebutting what we tell you. Rebutted version of the Congressional Research Service Report 97-59A, Frequently Asked Questions Concerning the Federal Income Tax, Form 08.006. This rebuts false statements or deception or propaganda from the Congress, essentially. And rebutted version of Dan Evans' Tax Protester Frequently Asked Questions, Form 08.007, available on the Family Guardian Sister site. You can find all the above and more in our Liberty University, Section 8, entitled Resources to Rebut Government, Legal, and Tax Profession Lies and Propaganda at the link provided there. If you would like to dig deeper, then you can learn much more detail about the subjects in this short course. Please refer to the following resources: Basics of Taxation, Liberty University, Section 3, available at that link. Income Tax Withholding and Reporting Course, Form 12.004, available on our forms page. Great IRS Hoax, Form 11.302, details about the tax fraud, available on the Family Guardian Sister site. The Galileo Paradigm Book, Form 11.303, details about taxation in simplified form. It's an abbreviated version of the Great IRS Hoax. Federal and State Tax Withholding for Private Employers Book, Form 09.001. You can use this book, in electronic form to educate the companies and your business associates to make sure that they follow the tax laws or the tax codes and franchises. You can also read Federal Tax Withholding, Form 04.102, which is a summary of the statutes on federal tax withholding. And you can visit our site and obtain our master file decoder to decode your IRS electronic records to expose fraud and violations of law by the IRS in falsely creating a liability that you don't have. You can obtain tax response letter forms from SEDM Forms page, Section 1.7, which allows you to respond to unlawful federal tax collection actions, or Federal Response Letter Index, Form 07.301, to respond to unlawful federal tax collection actions, and available at that link. And State Response Letter Index, Form 07.201, respond to unlawful state tax collection actions, and the Non-Taxpayers Audit Defense Manual, Form 06.010, which allows you to to defend yourself against illegal enforcement and misrepresentation of the Internal Revenue Code by IRS employees. You can obtain that on our forums page. If you'd like to get connected further, other websites available include the Family Guardian website, which is a sister site of ours. They have a lot of links to ours, although we're not responsible for their content. You can visit our site at Sovereignty, Education, and Defense Ministry, sedm.org. You can also visit We the People Foundation for Constitutional Education. And you can go to various freedom websites. These are only just a few. There are lots more. USA the Republic, Show Me the Law, and National Organization to Stop Socialism, now, no SSN. Legal research sources include the Legal Research Sources page, the Family Guardian, the Family Research DVD, which is a very complete legal reference library on one DVD, includes all titles of the U.S. Code, regulations, organic documents, etc. Cornell University Legal Information Institute is a free resource that we use all the time to look up statutes and regulations. The Electronic Code of Federal Regulations, which you can look at online on the government website. Versus Law, which is case research, and it's a fee-based subscription service. Find Law, which is free. And the USSC Plus Supreme Court CD, and that product has since been discontinued. And what about us? Sovereignty, Education, and Defense Ministry. We are founded in 2003. We are a nonprofit Christian religious ministry. Our mission statement is found on our About Us page. And our articles of mission completely describe how we're organized and what our purpose is. Form 01.004, available on our forums page. We are managed by a board of ordained ministers. Our ministry offerings are completely consistent with materials found on the Family Guardian website. Educational course materials are available only to members who must be non-residents and non-taxpayers, not engaged in the trade or business, and who believe in God. And all educational materials are obtained online only. We do not mail out printed versions. And a signed member agreement, Form 01.001, is required to join or obtain any ministry offerings. And we are based out of, but not domiciled in, Canada and outside of the jurisdiction of the United States government. And we focus exclusively on human beings and not businesses or artificial entities of any kind. And you can read our About Us page for further details on our ministry. And you can see our Frequently Asked Questions page, which answers most of the questions to or about us, so that we don't have to keep answering them over and over again. We want to emphasize that we are not anti-government, but pro-self-government. And we are not tax protesters, tax defiers, or tax deniers, but rather a legal education and law enforcement ministry. And by law enforcement, we mean God's law as well as man's law. We do not offer any kind of investment or tax shelter or engage in any kind of commerce within the jurisdiction of the United States. We do not provide legal advice or representation, but we do provide assistance of counsel. We do not allow our materials or services to be used for any unlawful or injurious purpose. We do not make legal determinations about your status. We do not market, advertise, or promote anything or pursue any commercial purpose. Our goals are exclusively moral, spiritual, and not financial. We do not interact with the IRS on your behalf. We do not offer asset protection, trusts, or corporation souls. We do not make promises or assurances about the effectiveness of our materials or information. We do not represent anyone using IRS Form 2848 Power of Attorney forms. We do not prepare or advise in the preparation of tax returns for others. We do not allow our materials or services to be used to interact with the government or legal profession on behalf of taxpayers, U.S. citizens, U.S. persons, U.S. residents, or any instrumentality of the federal government, including especially public officers. We do not connect ourselves with a trade or business in the United States or any government franchise. We do not engage in factual or actionable speech. All of our offerings constitute religious beliefs and opinions that are not admissible as evidence pursuant to Federal Rule of Evidence 610. Only you can make them admissible as evidence by signing them under penalty of perjury as part of an affidavit that you prepare. And we do not advocate or endorse any of the flawed tax arguments identified by the courts in the following document, Flawed Tax Arguments to Avoid, Form 08.004, available on our forums page. For rebutted arguments against this ministry, see policy document, Rebutted False Arguments Against This Website, Form 08.001 on our forums page. SEDM does offer voluminous educational curricula. We offer response letters, which are automated responses to common state and IRS tax collection notices, and you will need to have Microsoft Word to edit and assemble these. And you can obtain these at Federal Response Letters Form 07.301 or State Tax Response Letters Form 07.201. We also offer electronic books, Tax Fraud Prevention Manual Form 06.008, which describes how to protect your status as a non-taxpayer, the Non-Taxpayer's Audit Defense Manual Form 06.011, which is how to deal with a tax audit, Sovereign Christian Marriage, which is how to get married without a state marriage license, Secrets of the Legal Industry, Litigation Tool 10.003, which provides critical details on how to litigate in court for neophytes by Richard Cornforth, IRS Document 6209, how to decode your IRS tax records, Social Security Policy Manual, Form 06.013, how to live without an SSN, Defending Your Right to Travel, Form 06.010, how to drive without state-issued license and without becoming a resident of the corporate state, and What Happened to Justice, Form 06.012, which shows the corruption of the federal courts system and how to destroy any civil or criminal prosecution by the government. We also offer CD-ROMs, the Liberty Library CD, Forms 11.102, collection of free materials of the Family Guardian website for those who have slow dial-up internet connections, the Tax Deposition CD, Form 11.301, which contains questions to ask the IRS at a deposition, includes extensive evidence, Highlights of American Legal and Political History CD, Form 11.202, exhaustive history of the systematic corruption of our government and legal systems from the founding of this country, and also What Happened to Justice CD, which shows the corruption of the federal court system and how to destroy any civil or criminal prosecution by the government. It also has extensive backup evidence. We also offer DVD-ROMs, Legal Research DVD, Form 11.201, very comprehensive legal reference library on one DVD, Family Guardian website DVD, Form 11.103, which is the entire Family Guardian sister site on DVD-R media, the Sovereignty Research DVD, Form 11.102, which is the entire SEDM website contents, excluding items available through the Ministry Bookstore, plus IRS DVD from Family Guardian website. DVD movies, How to Keep 100% of Your Earnings by Mark Lucas, and Breaking the Invisible Shackles by Sherry Peel Jackson. Legal pleadings, we offer several of those. Individual master file decoding and rebuttal. We have two pieces of software, the Master File Decoder Standard and the Master File Decoder Professional, depending on your interest level. We also offer full service IMF decoding for single individuals or married individuals. And we also offer Liberty University, which is a free curriculum to teach you about law and freedom, which contains several movies, the federal and state withholding options for private employers, what to do when the IRS comes knocking, Form 09.002, how to handle the IRS raid, and much, much more. In conclusion, there is much to know in order to effectively combat illegal activity of all kinds by the government, including illegal enforcement of the tax code by the IRS. SEDM exists to provide educational materials that will help you get educated, and we won't fight the battle for you, but we provide tools to help you in your own fight to defend your rights as a non-taxpayer and a sovereign American national. We can only educate and equip people who consent to our member agreement and who are non-taxpayers and who are not statutory U.S. citizens, persons, or U.S. residents, and who have no income connected to a trade or business in the District of Columbia or the United States government, and who live outside the federal United States or federal zone, and who have committed themselves to getting educated so the IRS can't exploit their ignorance to victimize them, and who do not have any contracts or employment with the federal government. Getting educated and being vigilant in defending your legal rights is the key to staying sovereign, and we want to help you get educated, be self-governing, and separate yourself from the government matrix. We as believers are the church, and everyone else is the state, and we seek separation of church and state. If you have further questions, then we refer you to our frequently asked questions page on the SEDM.org website. You can also visit our forums and ask questions of us and other members, but you must become a member yourself. And so if you want to go to our forums and join, which is free, basic membership is and always has been free, go to http://sedm.org and then click on forums in the menu at the top. Thank you very much for your patience in listening to this rather long presentation, and God bless you all.